pronouncement of judgment against the interest of the institute.
The petitioner has made a calculation of the claim in Annexure 24 on the broad heads, which is roughly as follows. Our total of rupees 1 crore 31 lakhs, so and so. Apart from the claim as aforesaid appears to be astronomical, the said claim is wholly untenable for reasons more than one. Firstly, there was a charge of unauthorized absence for a period in question which was established in the disciplinary proceeding, followed by the penalty of removal from service. Secondly, such claim is barred by the principles of no work, no pay, and there is nothing on record to show that such situation had emerged for any omission commission not attributable to the petitioner. This court has also noticed that in the charge so prepared, the petitioner has made the following statement: starting salary for the period of so-and-so at the rate of so-and-so without non-practicing allowance. It is clear from the aforesaid claim that the petitioner was never taking non-practicing allowance, which indicates that the petitioner was in active private practice as a medical practitioner. From the above, it appears that by means of this petition, the petitioner has abused the process of law by which a wrongful gain has been sought to be made by causing wrongful loss to the state exchequer. For abusing the process of law, that too in a court of equity, this court is the opinion that an exemplary cost is required to be imposed on the petitioner. However, considering that the fact that the petitioner is about 66 years, this court has taken a lenient view on the above aspect and not imposed any cost. Writ petition dismissed, records returned.
May please Lordship for listing their motion matter Lordship on Friday Lordship.
If on the first thing. Oh, there is Vikram. Oh, which bench?
The bench 3 Lordship.
Bench 3 amani. Pump.
Bench 3 only.
No, bench 3 to that is
Bench 3 is photo 7 only.
7.
Whole particular transfer the
3 mentioned everybody. 3 for 3 there is another bench, not this.
The notification is there Lordship.
It's only for the matters before the other bench. Series matter relating to bench only for series matter. Salary. It okay, 2 and 3 क्यों दुटा this? Salary, your payment of salaries. Your matter is relating to what?
Pension matter Lordship.
Pension. Okay, motion matter.
Motion.
Okay, when do you want?
Friday Lordship.
Okay.
My lord, the admission matters.
Which bench?
Fourth, my lord, property.
4.
Yes.
When do you want?
13th Monday, next Monday,
Matter of which year?
2024, my lord.
24, why?
My lord, it was for 3 weeks time has been given.
No,
But-
not by mention memo. If there is no urgency, no mention memo. Sorry. Yes.
Wait, please, Lordship. I beg to mention item 46. Lord,
Yes.
I am appearing today, my lord, on Lord, that's the matter.
4-6.
Yes, my lord. The government has filed an affidavit, my lord. We would like to file a reply. So let the matter be taken up after 2 weeks.
When did the government file the affidavit?
It was, my lord, in fact, we will be filing our wakalatama today, my lord. There is one problem. Sir.
Or you'll be entering
Yes,
appearance today?
Yes, yes.
Item number 46.
46.
For respond number?
No, for the petitioner,
Okay,
Yeah,
you'll be
that's
the
what
new
I'm-
counsel.
new counsel.
Okay. Sri R.J. Learned Counsel submits that he has been instructed to appear on behalf of the petitioner and would be filing the wakalatnama today. Full stop. He further prays for and is granted 2 weeks time to file rejoinder affidavit. List after 2 weeks along with the wakalatnama and rejoinder affidavit. Age and VTA informed.
It is the government.
No, animal husbandry and veterinary.
I'll inform.
No, don't say, what is this I'll inform, Mr. Dev? There is a special counsel, you have to inform her, not like
I'll
this.
inform.
I will not do. I will not do. You know, you are a seasoned person.
I'll just follow.
Information is required. We are not going to adjourn matters without information or
I'll
consent.
just inform you. I'll just.
May I
Yes.
please, sir? I'm mentioning for listing, for admission call,
Matters of which bench?
bench 3, your lord.
Bench three, what is the subject
It's a
matter?
matter relating to compulsory retirement, your lord.
Compulsory retirement not
Your
before this
lordship,
bench.
this person, he is going to
It's
attend.
not before this bench. Bench, it's a different bench. It's only certain matters of bench three, yes.
May it please your lordship. Your lordship, I beg to mention item number 22.
2, yes.
Your lordship, the engaged counsel of the respondent number 1 is out of station due to some medical urgency. Therefore, she couldn't appear before this honorable court today. Your lordship, may please pass over the matter for
Who
the
is the engaged counsel?
Ms. As does.
You inform the other side?
Yes, your lordship, we have informed the petition.
Okay. When is she coming back?
After 20th of May, your lordship.
Okay, we'll adjourn this. It is submitted that Ms. Asdas, Learned Standing Council, Industrial Cooperative Limited,
Yes, your
Industrial
lordship.
Cooperative Bank Limited is out of station due to some medical emergency. Full stop. Para. As prayed for. List. Today is. List. After 2 weeks. Yes.
Highly obliged, your lordship.
Yes.
May I please, I prefer listing of a matter for admission, my lord, regarding my lord,
Which bench?
bench, my lord, regarding my lord, payment benefit. My lord.
Retirement benefit. Payment of salaries allowance pertaining to. Okay.
My lord. Next,
For motion.
no, my lord, admission,
Admission, which year matter?
my lord, 2020.
23.
Yeah.
Okay. My retirement benefit.
Highly-
Next week. Okay.
So back to item 39, lordship.
39.
Engaged counsel out of town, lordship. Matter may be adjourned for a week
39 is of 2023. You're for whom?
for petitioner,
Petitioner. Who's appearing for the
M.
respondent?
Islam.
No, respondent's elementary education. Have you informed?
Yes.
He's out of station.
Out of
It is submitted. That's M. Hussein.
M. Islam.
No. M. Hussein is out of station.
M. Islam.
M. Islam is out of station. That's M. Islam. Learned counsel for the petitioner is out of station. And accordingly, an adjournment is sought for. Para, list after a week.
Obliged.
Yes.
May I please, your lordship? Lordship, I'd like to mention item number 48. I am for
48.
respondent number 5. Yes, lordship. 48.
Hmm.
Lordship, we need 3 weeks time to file our affidavit in opposite.
Okay, you're for respondent number 5.
Yes, Lord.
Who's 5?
Assam Clean Tribes Development Corporate.
On a request made on behalf of the respondent APTDC, 3 weeks time is granted to file affidavit in opposition.
Lordship,
Others have filed?
Lordship, I appear for the petition in this matter, Lord. The date may be.
Others have filed?
Lordship, they don't need to file.
No,
They
have they filed or not?
No.
No, your lordship.
The rest of the respondents may also file their affidavit in the meantime. Para list on? Yes, kiman time dilo mein? 2 weeks, 3 weeks.
3
Yes, we fix a date then. List on. 1, 2, 3. List on 31st of May,
obliged.
Obliged.
31/5.
Lord,
Yes,
will I've informed.
okay.
Please no.
Did divide. This was item number, Mr. Day,
46.
46. Order distributed.
May I please, your lordship? Lordship, I beg to mention for item number 42.
Yes.
Learned counsel for the petitioners is out of station. Kindly pass over the matter.
Health department informed.
No, your honor.
You have to inform the standing council health department. There are standing council, inform them, then you make a mention. Not now. Yes.
May it please your lordship, I beg to mention item number 24 and 25. Can it be passed the vote for the day because the counsel for the petitioner, Mr. G. Pathak fell unwell, so. Can it be taken
24
up?
also he is there.
Yes, 24 and 20.
24 his name is not there.
It is a tag matter.
24 have you informed the petitioner's counsel?
For the opposite side.
No. 24 there are
No.
other counsel for the petitioner.
No, I have no contact details.
No,
with
you have to
them.
inform them. we'll adjourn it.
Okay.
We'll accommodate you.
Okay, I'll.
You
inform-
get hold of the counsel for the petitioner in Pradeep
Maybe.
Sharma's case, inform them.
Okay.
And are the respondents counsel the same? Almost the same, yes.
Okay. Obliged,
Inform them, then
Okay.
we'll see.
obliged.
Yes,
Wait, please, your Lordship. Lordship, I beg to mention item number 43, Lordship.
43,
Yes, Lordship.
yes.
Lordship, engaged counsel could not appear, Lordship. Y.S. Mannan. Lordship, I beg for pass over for the day.
Why, he's got some personal
He is
difficulty?
not well, Lordship.
Okay. It is submitted that Sri Y.S. Mannan, learned counsel for the petitioner, is unwell, and therefore a prayer for adjournment has been made. What about GMC, informed or not?
I have contacted Y.S. Mannan, sir. He has instructed, he has informed.
He is,
already.
okay. List after 2 weeks.
Obliged, sir.
May I please, your lordship? My lord, in view of the last order, 2nd of February, my lord. Respondent 5, my lord, implemented and already amended the title, my lord, and matter pertains to, my lord, the petitioner retired from service on 31st October 2016 from the Nalbari Municipal Court, my lord. And thereafter, my lord, he may approach the different occasion and the last year on representation made on 13/9/2000 to release of the air salaries and other benefits, but it is not responded yet, my lord. So it is not before this. Lordship, page Annex 11, Annexure 2, my lord. By this letter, I'm being informed that my retirement is 31st
Okay.
October 2006.
Third, Sri P.K. Dekha, learned counsel for the petitioner. Full stop. It is projected that the petitioner had retired from service on 31/10/2016 as a road mahurar, MAHURER, who was appointed by the Nalbari Municipal Board. Full stop. However, the arreared salary, leave encashment, gratuity, and other post-retirement benefits have not been released to the petitioner in spite of representations being made. Full stop. Para,
Page 14, Annexure 5.
notice be issued. Returnable by 6 weeks. Yes, state, Mr. Sharma. Who's appearing? MAD, Municipal Administration. And District Commissioner Nalbari, that you can appear, I think. Who's for the government? Mr. Sharma, you're not for the government. Or who's for the government? Government council? Who's there in the court otherwise, Mr. Borpujari? Anyone? Any government council who would appear? Who's in the court?
Municipal administration, perhaps my lord Santanu Bora can take
Or is
over.
he there?
Yes, he's there.
And no, other government
Others,
council.
my lord, others will be represented by my lord the government.
Who's there? Name one of the council who can appear. Any government council who.
Let me record the name of M. Bormon, junior government advocate. He is there today. in the court.
Okay.
Meghali Bormon.
Sri S. Bora. He's there in the court otherwise, that's Bora.
He is there.
Sri S. Bora, understanding council.
Meghali Bormon again.
Standing Council Municipal Administration Department accepts notice on behalf of respondent number 1, whereas Miss M. Bormon, learned State Council, accepts for respondent numbers 2 and 3. Oh no, this is not this. I'm sorry. This is the amended cost title concern. I don't know. For 2, 3, and 4. Executive officer, I think government council can take instructions.
Yes, my lord.
1, 2, 3, and 4.
Okay.
Let extra copies be served upon the learned council
By
by tomorrow. let steps be taken for service of notice upon the response number 5 by registered post with AD. Tar আগত এটা লিখিবা, Sri Deka has submitted that in terms of the order dated 2/2/2024, comma, he has filed amended cost title incorporating further respondent. সেইটো ওপৰত থাকিব, তাৰপিছত
My lord, I one more prayer, my lord. Since my representation since 2020 is pending before Lord, during pendency, if they consider, my lord,
pendency shall not be a bar for consideration of the representation of the
13/9
petitioner.
2020, if you apply.
My lord, your lordship may peruse the order dated 23/24,
20,
203.
okay. Notice was issued.
My lord.
Lordship,
What happened to the inquiry? Yes, inquiry proceedings, what has happened?
Lordship, we have yet to receive that inquiry report, Lordship. Otherwise, partly we have received the instruction, Lordship. As per our instruction, Lordship, the petitioner is within the ambit of that illegal and irregular teachers, Lordship. Although they received salary up to 2014 by creating supernumerary posts, but subsequently they were supposed
You
to.
file affidavit,
We will file affidavit.
you file affidavit. Why has it come for no motion, Mr. Roy Chaudhary? Do this matter? No, Harsri, R.K. Roy Chaudhary, Apike Roy Chaudhary, Learned Counsel for the petitioner. Para, though this matter has been listed under the motion column, comma, it appears that by the order dated 23/2024 BISA, notice of motion was already issued and instructions were directed to be obtained more specifically on the aspect of the inquiry which was initiated on 9/5/2012. What's the para? Sri P.N. Sharma, Learned Standing Counsel, Elementary Education Department, submits that some instructions have been received as per which the petitioner falls within those illegally appointed,
Illegal and irregular.
illegally appointed teachers, illegally appointed stipendary teacher. Puts the para. The complete instructions are required to be put on record by way of an affidavit so that the petitioner gets a fair chance to respond to the same. Full stop. List after 3 weeks for to enable filing of such affidavit in opposition. You are for AG? SK Medi, AG, huh? Board Pujari, the finance department.
May I please? My lord, it's a transfer matter, my lord. What happened, my lord, on 21st/7/2023 and 21st/7/2000 by.
I have filed on 6/5, but it's not yet there with the record, Lord.
Is there any stay order?
Yes,
Yes.
Lord.
There is a stay order.
Yes.
Let the affidavit come, then we can finally dispose of the matter.
Yes, Lord.
But why notice has not been issued?
Notice not yet.
We'll do one thing, we'll issue notice, make it returnable on a particular date, and admission stage will dispose this of.
Lordship short date, maybe.
Short date, we'll fix a date,
My lord,
since
in
affidavit-
spite of the stay order, my lord, they are not allowing us to join our post mill.
Already spare order were passed before passing of the interim order. So that is in a almost a status quo petition at
But
present.
the transfer order has been stayed.
Okay, Howard Sri I. Rafiq, Learned Counsel for the petitioner. Full stop. On, full stop. Also heard, Ms. B. Sharma, learned CGC, full stop. Para. It appears from the order dated 3/4/2024 that the matter was considered at some length and an interim order has also been passed with regard to the impugned orders of transfer and the subsequent orders. Full stop. Para. Sri Rafiq, the learned counsel for the petitioner, has however complained that in spite of the stay order, comma, he has not been allowed to join. Full stop. Para. Ms. B. Sharma, learned CGC, however, submits that before the interim order was passed, comma, subsequent order was already passed. Full stop. She has further informed this court. Subsequent passports, whether such a defense would be available to explain non-compliance of an interim order would be decided on the next stage. Full stop. The learned CGC has however informed this court that the affidavit in opposition.
Not opposition, I have filed a reply to their additional affidavit. That is the direct.
That a reply affidavit to the additional affidavit of the petitioner has been filed on
6/5.
6/5, which however is not with the records. Full stop. Para. In view of that, let notice be issued returnable on today's returnable on 14th of May. Who are the respondents?
This is NF Railway, RPF.
Who is appearing? You would be appearing?
Yes.
Ms. Sharma, the learned CGC accepts notice on behalf of all the respondents. Full stop. No, since this matter was considered earlier, comma, no formal notice, no formal steps are required to be taken. Full stop. List on list on the returnable date, that is i.e. 14/5/2024 for admission hearing, along with the and the reply affidavit. Full stop.
Okay.
Interim order to continue till the next date fixed. Item 4.
In this case, my lord, petitioner was working as a Gaupura in 2 villages, and he was suspended on being arrested in connection with a criminal case. And thereafter, my lord, on being reported by the concerned circle officer with regard to his arrest, he was suspended from the state post. But the suspension order was not directly communicated to the present petitioner, and he was on being inquired after release on bail, gone to the office of the DC, Kamruk, and he came to know that he has been suspended. And immediately within a period of 2 or 3 days, he has filed a representation with regard to revoke of suspension, considering his release on bail. And the said case is pending for trial in the appeal trial court also against him. So, but since after passing of 1.5 years, no intimation on the part of the official.
What is the stage of the criminal case?
That is evidence stage, and most already going to
What is
be
the charge?
charges under NDPS. Sir.
NDPS.
Yeah.
Gaupura.
Gaupura. He has been falsely implicated. If you lordship would peruse the
Which
evidence-
section? Which section?
Which section?
What quantity?
No, small quantity. Small quantity. Opium. No possession has been proved till date.
Okay, that's a different aspect. We are not going to that aspect. Yes, Mr. Doctor.
Against the order of suspension, there is the appeal provision, statutory appeal. Appeal is-
Why don't you treat his representation as a statutory appeal?
Appellate authority is Lordship,
Commissioner,
Director of Land Record.
and it's,
Appointing authority is TC. Against the order of TC, appeal is like before a PLR, Director of Land.
now
Record.
there was a change in the appellate
So
forum.
that is the new.
Earlier, who was the authority?
Earlier divisional commissioner was
Divisional, now the director.
Director of Land Record.
Okay.
From which date?
You had filed the representation when, Mr. Paul?
We have filed representation 22 November 22. It was on 24. That way.
Then also
Lordship may,
Where is the order of suspension?
Lordship may find at page 37.
Mr. Paul, that is the only ground.
Yes, actually, what with regard to the law, your lordship must aware about the fact that after 3 months, any suspension order to be reviewed or to it should be intimated to the incumbent. What happening with regard to the status of the order issued by the competent authority against the concerned person. But in
Okay.
this case, my lord, neither any communication on the part of the official respondents nor any appropriate further extension of the said suspension. So on that ground, I have approached before your lordship or to direct the respondents to dispose of his representation, whether his suspension to be continued.
Gambura post, it is not a transferable post,
No,
isn't it?
Not transferable.
So is no, there is no scope of posting him somewhere else.
No.
So where is your discharge of your obligation of making a periodic review?
and there is no statutory rule.
Hmm?
There is no statutory rule.
No, Gambura is a civil post, isn't it?
He is governed by the all rules of the government.
Governed by the.
No, the periodic review, it is a matter of principle. 90 days, there's strict principles. We may not be on that, but it's a matter of principle. It's good practice that you have to review periodically, and 90 days has been held to be a standard period. Whether you want to extend or revoke, you need to communicate. If you want to extend, you can just apply your mind that yes, criminal case is pending. We on the satisfaction, we may not go, we may go. That's a different matter. But you have not even applied your mind.
That has to be taken, we have to take instruction because have suspension order issued by TCL. Deputy Commissioner.
Yes,
That
that
has
I
to be
remember.
taken instruction, we have to take instruction.
See, so far as suspending him, the observations which you have made in the order of suspension at page 37
Sir.
is in sync with the 1964 rules,
Sir.
48 hours.
Yes,
So if you are following that rules for one purpose, that rule has to be followed for other purpose also.
but that.
It's for emotion or what?
Yes,
So,
most-
We, yes, we'll issue notice, but you take instructions. Hard. Mr. Pal, that should be your main ground. You are going for representation.
Yes.
Periodic review should be your first ground.
Yes.
2022 suspension, nothing. Periodic review, no communication. What else do you need?
I have stated in the petition.
And what is your reaction towards that this suspension is on account of a criminal case? What is your submission?
Because I am defending myself in the trial court. So far as.
No. Whether that analogy would be applicable even in a criminal case, what is your take?
I have not understood.
See, this analogy of periodic review is only in contemplation of a disciplinary proceeding.
Yes.
Now, here is a case because you have been suspended because of your 48 hours in the custody. Will the same analogy apply? If yes, where do you rely upon? Which case law?
Ajay Kumar Chaudhary.
Ajay Kumar Chaudhary is not very clear. There is something else.
And moreover, my lord,
You're not aware.
disciplinary action should be also may be initiated against me.
Hmm.
Further
You have not
pending-
understood. Ajay Kumar Chaudhary has not said anything about criminal case. A division bench has said.
I have to go through Ajay Kumar Chaudhary because the long time.
Not
I have
Ajay Kumar
studied.
Chaudhary, a division bench has said. Whether Ajay Kumar Chaudhary or principles of Ajay Kumar Chaudhary will be applicable even in a criminal case where 48 hours, the suspension is account of 48 hours custody. You have not done your homework. Heard Sri Pal, learned counsel for the petitioner, who is aggrieved by a prolonged suspension order dated 13/9/2022, whereby he was suspended from the post of Gaunbura, within bracket Gaon Pradhan, in the Barkukuria
Barampur village.
Barkukuria and
Barhampur.
Barhampur villages under Rongia Revenue Circle in the district of Kamrup. Full stop. This age suspension is on account of the arrest of the petitioner in connection with Rongia PS case number 541/2022. Full stop. The learned counsel has submitted that his representation has submitted that till now there is no information about any periodic review and the reason of continuing with the order of suspension. Full stop para. That notice be issued, returnable by 4 weeks. As Dr. Learned Standing Counsel Revenue Department accepts notice on behalf of respondent 1. Madam for 2 and 3. M. Bhattacharya, Learned Edition Senior Counsel for 2 and 3. Extra copies within 2 days.
Okay.
Student Sri Datta has by placing on record a notification dated 1/2/2024 of the Revenue Department has submitted that there is an appellate provision and the appellate authority as per the said notification is the Director of Land Record.
Okay.
Item 53, supplement is along with item 40.
Along with item number 40. 40 Upil Pune. Same. Built up Lakiba. None appears for the petitioner on call, whereas the respondents are represented by who's appearing, Mr. Borpajar?
For the finance department.
By represented by Sri R. Borpajar, Learned Standing Counsel Finance. You are also, and P. N. Sharma, Learned Standing Counsel Elementary. Second, Learned Counsel Education Department. Full stop. Para. This matter has been listed on behest of the petitioner who had filed a mention memo. And thereafter, the petitioner is unrepresented. Full stop. Para. A process of this court is not permitted to be abused in this manner. Full stop. Para. List after 2 months. Para. In this period, no mention memo is to be entertained.
May I please the Lordship, can we have a look on the last order, 28?
Lordship, amount has been released, Lord.
You show it to him. Show it to Mr. Decker.
My client has not communicated me yet.
He'll now not
It
communicate.
has been sent to the, it has been sent to the headmaster of the school, he will take, Lord.
Heard Sri P.K. Decker, Learned Counsel for the petitioner.
Thank
Who has filed this writ petition for release of his GPF final and what is NRA
NRA,
Non-refundable
non-refundable
advance.
and NRA? Full stop. It is stated that the petitioner had retired as a grade 4 employee from the Rahmatganj Senior Madrasa, which is presently Rahmatganj High School in the district of Dhubri. Retired on 30/9/2017. Date to my retirement date to. Full stop. Para. This matter was considered on 28/2/2024 when Sri B. Chakraborty, Learned Standing Council AG, was directed. No, when the Learned Council for the respondents, including Sri B. Chakraborty, Learned Standing Council AG, were directed to obtain instructions. Full stop. Para. Sri Chakraborty, the Learned Standing Council, has submitted that wide an order dated 3/4/2024, the amount in question has been released
Along with interest.
and the same has been communicated to the concerned headmaster of the school. Full stop. He has also placed on record a copy of the written instructions dated 26/4/2024.
Headmaster is the respondent number 6.
26 full stop. Para. The copies of the said copies of the aforesaid order and communication are also shown to Sri Decker, the Learned Counsel for the petitioner. Full stop. Para. Petitioner who, however, submits that he is not aware that his client has not informed anything in this regard. Full stop. Para. Be that as it may, in view of the aforesaid development and also the specific written instruction and the order and the connected order being placed before this court, this court is of the this court is of the opinion that there is no further requirement to proceed with this petition. Full stop. The petition as the grievances of the petitioner appear to have been redressed. Full stop. Para. The writ petition accordingly stands disposed of.
Respondent number 6 may disperse the.
Yes, ma'am. Respondent 6.
The amount in question is now required to be disbursed by the respondent number 6 expeditiously, and in any case within a period of 4 weeks
My lord.
from the date of receipt of the certified copy of this order.
Keep the
I'm for 120.
PN Sharma. Elementary or what?
Elementary.
Elementary 1, 2 and 3. Borpuzari 5, finance. Treasury officer, finance department.
Item 5.
Yes.
This is the petitioner. He retired as a public relation officer on 31/1/2019 on the
Hmm.
service of respondent number one.
Hmm.
But he was not paid with the leave encashment amounting to rupees 6,89,000.
Okay.
But thereafter the respondent filed their affidavit. They have admitted my claim, but they said that due to paucity of fund, they could not make payment. They filed their affidavit on 22/8/2021.
21.
Yes, sir.
Yes, you're appearing.
Yeah, please, madam.
Oh.
My lord, I'm appearing for respondent number one and
Who's 1 and 2? Urban.
Urban
Okay.
on behalf of Mr. SP Shastri, madam.
Okay. Okay.
My lord, the said respect, my lord, can kindly see the order dated 9/12/2022.
9/12/2022.
Yes, sir.
Yes.
Here, my lord, it has been stated that since there is a paucity of funds, the board has requested the government to provide us certain financial assistance for
Hmm.
supplementary demand by this particular.
Hmm.
My lord, again, the said respect was considered on 11/4/2023.
Yes.
The last paragraph, Mr. Arvind Das, Planet Council, during the course of hearing, we have provided the copy of it, and we have said the status as of today is unaware.
But this matter was directed to be listed in May 2023.
No.
We are in May 2024. What have you done?
My lord, see, initially, Mr. Arvind Das was hearing on behalf
No,
of.
no, we are not too much concerned with that.
Yes, my lord. My
What
lord,
have
may
you done
kindly
with this?
provide us 3 weeks.
But
No, no, not
no-
at all.
no step has been taken as per information of my client.
Not at all. No 3 weeks business. The matter is pending since 2021 on the issue of lack of funds.
Yes.
We see what lack of funds you are having. You go out, you see the lack of funds. How much funds are being used. Yes, please, for the government. Finance Department, Mr. Borpujari. Madam Sharma, Borpujari, call Mr. Borpujari.
In 2021 in affidavit, the same thing was repeated in paragraph 5
Affidavit by whom?
by respondent number 2. Managing Director, the internal page 3, paragraph 5.
Let Mr. Borpujari
Yes.
come. We'll pass some directions.
Yes.
Mr. Vishwakarma will be here.
Yes.
Yes, he's come. Are you aware of this matter, Mr. Borpujari?
Item number 5. Number 1, serious.
He has
Because finance is not a party.
understood. Urban Development Department is a party.
Perhaps my colleague, Mr. P. Nayak, he will be in a better position because he appears for UTD.
UDD. No, because of lack of funds by the Sewerage Board, one component of his post-retirement benefit, leave encashment, has not been paid. And he is retired in 2021. And in the affidavit, board has clearly said that we have asked for the funds as and when funds will be there. And now thereafter matter is pending for 3 years. Will it look good on paucity of funds?
If Lordship may accommodate me for a time being, my lord, I can call Mr. P. Nayak.
Let Mr. Nayak appear.
Because he has been dealing with this kind of
No,
matter.
yes, yes. Yes.
My lord, will peruse order dated 1/6/2022.
1/6, yes. You've got the appointment order.
My lord, I have got the appointment order. The respondents were directed to submit the minute. The exact document your lordship will find in an order passed in IA 1184, which has been disposed of. So in that IA, there was a clear direction to them to submit the,
No, 1/6/2022,
is in the writ petition.
that you have just referred to.
My lord.
Sri so learned counsel for the petitioner shall produce the appointment order of the petitioner.
Yeah, I have that one.
Let us first
Right.
see that. Madam, you have a look.
Lordship, this matter,
Have you seen this letter?
appointment order, I have
Have a look. Can you pass into the court? What is your name, Mr. Chakraborty? Bidyut.
Vidyut.
Yes. Monthly rated skilled. I have appointed temporarily growth. That's Khalasi. This is in where 89.
Right.
Okay. This is where? In
This is
Karimganj.
fine, fine.
Now, what is your claim
My lord, my name appeared in the provisional select list
for?
for promotion from the post of Khalasi to section assistant. Thereafter, without objection being raised against the provisional list, it was finalized in the final list. There it appeared in serial number 58. Thereafter, a selection committee was formed and the approval of the selection committee was awaited. In the meantime, I
That
went
first
into
list was a select list or gradation list, seniority list?
provisional gradation list.
Gradation list.
Seniority. Seniority.
Those will be considered for the purpose of selection to the
Yes.
higher post.
Yes.
Now, there was a selection board which was constituted.
Subsequently, my lord, there was a final list. After the gradation, provisional gradation list, there was a final list. In that also my name appeared.
Understood. Now, you came within the zone of consideration
Yes.
for selection to the higher post.
Yes.
Then what happened?
My lord, thereafter, my lord, the selection committee, my lord, took time in considering,
Finalizing, okay.
finalizing. So in the meantime, I attained my age of superannuity.
Okay.
That was on 39/2020. I thereafter preferred representation before the authorities that since I was under the zone of consideration, so my case for promotion on a notional basis may be considered. Now, that was not considered by the authorities. That's why I came before this honorable court.
Now, was there any person who was junior to you considered?
Now, look, subsequently, during the pendency of the writ petition, from that gradation list, somebody who was there in that list has been conferred promotion who is still in service. So I have not challenged that, man.
No, how, from where does your right germinate?
Well, notional promotion.
No,
my lord,
you were in a gradation list. It's
lord.
not a case that person below you were considered promoted at the time when you were in
No,
service.
no.
In the meantime, you have
Super-
crossed the age of superannuation. Where does your right accrue now?
My lord,
Where? Which place?
my lord, to that extent, my lord, there are authorities.
Let us see.
If, my lord. My lord, 2006, 13 SCC,
2006?
13 SCC 661, my lord.
2006, 13. This is 661. State of VP Roshan Singh. Paragraph?
My lord, paragraph, effective paragraph, my lord, paragraph 3 and 4, my lord.
Yes, please. 3. Yes, please read.
my lord, paragraph, may I read this two paragraphs, my lord?
Yes.
Briefly stated the fact as follows: the respondents so and three others were working as cooperative supervisors under the cooperative department. According to the relevant rules of the post of cooperative supervisor is a non-government post. They retired from service on 31/5/1996, 31/9/1990, 31/1/1996, 31/1/1997, and 31/1/1996 respectively. They filed writ petition number so and so seeking promotion to the post of cooperative inspector group 2 government post with effect from 7/4/1917 on the ground that on the same day the persons who were junior to them has been promoted. The learned single judge allowed the writ petition by an order dated 24/8/2000 following the decision rendered in Bengali Prasad Sharma case decided on 3/5/1995. In Supra, he said he had filed writ petition number 13240 SS of 1990 while he was in service. It is also not a disputed fact that Bengali Prasad was holding the post of cooperative inspector group 2, which is a governmental post, while he filed the writ petition. In that view of the matter, the High Court by its order dated 3/5/1995 allowed the writ petition filed by Bengali Prasad directing that he should be given notional promotion with effect from 7/4/1978 and he would be entitled to pensionary benefit from 7/4/1978. The learned single judge has committed a grave error in law by equating the cases of the respondents so and so and other three with the case of Bengali Prasad. It is now well settled principle of law that unequals cannot be treated equally. As already stated, the respondents so and so and three others were not holding the post of cooperative inspector group 2, which is a governmental post, and they retired from services. Therefore, the High Court was not justified in allowing the writ petition and granting the pensionary benefit with effect from 7/4/1978, as had been done in Bengali Prasad's case. Secondly, the respondents filed the writ petition in July 1997 after they had retired from service. Even on this count, they could not have been granted any relief sought for in the writ petition. The division bench of the High Court also committed grave error of law and facts by confirming the judgment of the learned single judge without assigning any reason. In the result, these appeals deserve to be allowed and are accordingly allowed, and the orders of the learned single judge and division bench of the High Court are quashed and set aside. The appeals are allowed, and the writ petition filed by the respondent stands dismissed. However, the parties are asked to create their own court. So this is one of the rulings, my lord. Then there is another ruling of 2010, my lord.
These appeals filed by the respondents. And appeals are allowed. Appeal of the state has been allowed.
My lord.
Okay, December and order of foreign resident. Holding. How does it help you?
Well,
It
this
is
doesn't,
it is against you.
well, this doesn't help me. It has been,
It is against you.
well,
Straight away against you.
this is straight away against me. Well, there are a couple of other rulings.
Why are you
my lord.
relying on this?
My lord, this was for differentiation, my lord. This was taken for differentiation. I have two other rulings, my lord. May I just place these two other rulings? My lord? One is 1993 supplementary 4 SSC 748.
1993. Madam, have your seat. We'll come to you. 1993,
Supplementary 4 SSC
Supply 4.
748. This, the relevant paragraph, my lord, would be may I please one more ruling, my lord. 2010.
No, which paragraph in this?
My lord, this will be paragraph, my lord.
What kind of assistance is this?
My lord,
Mr.
I am
Chakraborty?
taking, my lord, I am taking
You
back.
face some judgment, you do not even know the
My lord,
paragraph,
my
judgment
lord,
is
I'm
not
very-
relevant.
I'm very sorry, my lord.
You
Today,
bring out some paper from your file and place it before the court,
Madam,
wasting the court's time.
I'm very sorry, my lord.
This is
Today-
your assistance, level of assistance.
I'm very sorry, my lord. Today I was.
What sorry?
I'm totally taken aback, my lord, because
Why?
I was supposed to produce this promotion.
Why,
order,
why, why?
This appointment order, my lord. That's
Why
I'm-
taken aback? Why? It
My
was
lord,
not
your-
listed.
My lord,
Yesterday was not a working day.
my lord, lordship will take it after some time, my lord. I'll just.
Not at all. Yes, what is the
My-
next decision?
My lord, the next is 2010 for SPC 290.
Yes, citation?
2010 for SSC 290.
2010.
2010 for SSC 290.
Yes.
My lord, insofar as the notional promotion part is concerned, that has been dealt with in paragraph 35 and 36, my lord. Paragraph 35 and 36, my lord. May I read these two paragraphs, my lord? Paragraph 35, my lord.
Yes, please.
The court must keep in mind the constitutional obligation of both the appellant central government as also the state government. Both the central government and the state government are to act as model employers, which is consistent with their role in a welfare state. It is accepted legal position that the right of eligible employees to be considered for promotion is virtually part of their fundamental rights granted under Article 16 of the Constitution. The guarantee of a fair consideration in matters of promotion under Article 16 virtually follows from guarantee of equality under Article 14 of the Constitution. Now, thereafter, my lord, if your lordship will kindly see paragraph 48, my lord. The case, in this case also, there was delay on the part of the authorities. So paragraph number 48, if your lordship kindly takes up. My lord has got paragraph 48. The court is satisfied that in this case, for the delayed exercise of statutory function of the government has not offered any plausible explanation. The respondents cannot be made in any way responsible for the delay. In such a situation, as in the instant case, the directions given by the High Court cannot be said to be unreasonable. In any event, the court reiterates those very directions in exercise of power under Article 142 of the Constitution of India, subject to the only rider that in the normal cases, the provision of Rule 4.2 of the state cadre rules cannot be construed retrospectively. With the aforesaid modification direction, the appeals filed by the Union of India are disposed of. There shall be no order at the court. So in my case, my lord, basically my lord, contention is that though my case was forwarded for selection, my name was forwarded to the selection committee, but because of the delay by the selection committee, I attained.
When was it forwarded?
My lord, your lordship will kindly take up my petition, my lord. Paragraph number 20, page number 29, your lordship will kindly take up.
Yes, 29.
That was on 1/6/2020. This was the minute of the selection committee that was forwarded to the chief engineer, PET Water, by the executive engineer. So this was the official correspondence that took place on 1/6/2020. And my superannuation, your lordship will kindly see. At page 30, my lord.
Three zero.
30.
Yes.
So since during the stint of my continuation in service for the period after which my selection, minutes of selection was forwarded, since the promotion was not conferred, and I attained the age of superannuation, thereafter I preferred the representation at page 31, my lord.
Representation.
Yes, at page 31, my lord. Herein I stated, my lord, that just after 4 months of forwarding of for the minutes, I have been superannuated without being conferred the promotion. So I paid for conferring the notional promotion.
Okay.
Now thereafter, my lord, in the writ petition, notices were issued. And my lord, the respondents were asked to come up with their response. In the meantime, my lord, the development took place for which I preferred this IA. If your lordship kindly takes up this IA 1184 of 2022.
Disposed of.
Yes, and there was an order also in the IA.
What was the development?
My lord, the development was they had during the pendency of the writ petition come up with an order promoting one of the incumbents who was in that select list. And thereby, my lord, the promotion was effectuated on in pursuance of minutes of a meeting, which, my lord, was not provided to me. I did not have access to that minute. Nonetheless, I apprised this honorable court about the development that took place regarding giving promotion to one of the incumbents from that list. And pursuant to the IA that was filed, your lordship will find there's an order dated 1/9/2022 in the IA itself.
19.
Yes, yes.
I was disposed of 95.
This 95. I'm sorry, my lord. 9/5/2022.
Yes.
And then pursuant to this order, my lord, your lordship will see the latest order of the writ petition, that is 1/6/2022.
Here, it is the minutes of meeting of 2022, 3/2/2022.
My lord.
Order of?
Order of the writ petition dated 1/6/2022.
Yes.
Pursuant to which I have just supplied, my lord, the order of promotion, the order of appointment to
Yes,
your lordship.
that we have seen.
And they were directed to produce the copy of the minute.
Okay, if I may.
We will come to it. Yes.
But first and foremost, the appointment order itself says that his appointment is purely on temporary basis. And he was appointed as a Khalasi, that is a personal post. And employees holding personal posts are not entitled for promotion in the light of Dilip Talukdar's death. The appointment itself is on temporary basis.
Here for the PHE,
PHE department.
M. Kolita.
Yes, my lord.
It's a personal post.
It's a personal post.
Other Khalasis have been promoted or not?
No.
No
In
Khalas is
my
promoted.
knowledge,
My lord, the IA speaks otherwise. In the IA, I have annexed the promotional order.
Was he a Khalasi?
Yes. From the post of Khalas, he has been posted in the gradation list and thereafter.
there are several judgments, my lordship, when it has been held that Khalasis cannot be promoted.
Which judgment? Which judgment?
Dilip Talukdar, sir.
Let's place it.
If I do not have it with me now.
Then where are you referring?
If my lord is
If
taking-
page 14 come to page 14 of the IA.
and paragraph 9, page 9, paragraph 4 also. With Prakash Ghosh. I'm not against this promotion.
Mr. Chakraborty, we are on the order itself. Where are you going to the pleadings?
Yes, my lord.
Page 14, madam.
Not
This Vikas Ghosh is a Khalasi. You have promoted him to SA.
the promoted. Lordship may look at the last paragraph.
Yes.
Promotion is purely temporary basis and subject
Yes.
to reversion to the original.
That is
post
written
that you
everywhere.
had.
Will this mean that Khalasis are personal post cannot be promoted? And that is not the defense which we are expecting from you, madam. His writ is structured on a different footing. You have not even answered, not even a single word you have said on that. You have
But
gone on a different tangent.
Otherwise,
Khalas is our personal post. We are not on that at all.
Lordship, otherwise what we can do is we can consider his representative.
Is that your submission? That is what you submit in the court.
Lordship, because
Don't come with this kind of submission if you are not prepared with matters. We'll consider representation.
I do not have the up-to-date information.
As a lawyer, don't you think that there are defense available to you? You can raise those defense. If you don't know, ask your seniors, then you appear. What is the case projected? Have you understood the case?
But-
His name was into the zone of consideration. In the meantime, he retired. Then he had promoted persons who was still in the same select list. He is trying to get his right from that. Will a right be there? What is your defense? First question we are asking him, you could have got the queue during the time of your subsistence. Was any person junior to you appointed? Answer is no. Then where is the discrimination? You have not said a single word. Your mind is closed or what? That will consider representation. What kind of submission in this? Mr. Bhattacharya, for whom?
AG.
AG, anything? Yeah, please. Have a seat.
Well.
The writ petition has been filed with the following relief. Full stop. Relief to carry. The facts projected by the petitioner is that he was appointed as Khalasi, wide and order dated 13/12/1989 in the Department of Public Health Engineering, within bracket PHE, in the Karimganj PHE division. Full stop. A provisional inter-se seniority list of Khalasi was prepared, in which the name of the petitioner figured against serial number 66. Full stop. The said provisional list was finalized and the name of the petitioner had figured against serial number 58. Full stop. The said list was finalized on 29/5/2020. Full stop. A promotional exercise was undertaken by a selection committee which had held a meeting on 1/6/2020 for considering promotions to various vacant posts of grade 3 and grade 4. Full stop. As per the petitioner, though his name was recommended for promotion, before such promotion could be given effect to, the petitioner had attained the age of superannuation on 30/9/2020 and had retired on service, on retired from service, full stop. The claim of the petitioner is that that he is entitled to be given notional benefit of such promotion and accordingly the consequential post-retirement benefits. Full stop. Para. I have heard Sri Chakraborty, D. Chakraborty, learned counsel for the petitioner. Full stop. I have also heard Ms. M. Kolita, learned counsel representing the PHE department, whereas Sri D. Bhattacharya, learned standing counsel, appears for the Accountant General Assam. Mr. Borpujari also there? Okay, para. Sri Chakraborty, have your seat, madam. Sri Chakraborty, learned counsel for the petitioner, has submitted that his name was within the zone of consideration in the finals gradation list, wherein he was placed against serial number 58. Full stop. He has also contended that the date of superannuation of the petitioner was after about 4 months from the date when the selection committee had made the recommendations. Full stop. He accordingly submits that the delay in effecting the promotions should not cause prejudice to the petitioner, and he be granted the benefits of notional promotion from such date, and consequently all the post-retirement benefits, by construing that he had retired from the promoted post of grade 3. Full stop. Para. Sri Chakraborty has also relied upon the following case laws in support of his contention. 1, 2, 3. Cinta case law. Full stop. This court has, however, noted that the cases of Roshan Singh Supra and Nalini Kantas Sinha Supra are not relevant to the present subject matter. Full stop. In the case of Hemraj Supra, the Honorable Supreme Court has reiterated the requirement of a fair consideration for promotion. Full stop. The aspect of delay on the side of the respondent authorities was also considered by the Honorable Court. Full stop. Para. Per contra, Ms. Kolita, the learned counsel representing the department, has submitted that the post of Khalasi is a personal post and there is no promotional avenue, and therefore the petitioner would not have a right for making such a claim. Full stop. Sri D. Bhattacharya, learned standing counsel AG, submits that his client may not have an effective role in the adjudication of the present case. Full stop. Para. The tribal submissions have been duly considered and the materials placed before this court have been carefully examined. Para. It is not in dispute that the petitioner was a Khalasi, and in the gradation list, in the final gradation list, his position was serial number 58. Full stop. It is also not in dispute that that a selection committee was constituted, which had held a meeting for promotion on 6/2/2020. Full stop. The contention raised on behalf of the department that a Khalasi is not entitled for further promotion is not supported by the documents on record, more specifically an order dated 22/3/2022, by which an incumbent Sri Vikas Ghosh Khalasi of the same Karimganj PHE was given the benefit of promotion to the post of section assistant. Full stop. What is, however, germane to the issue raised is as to whether the present claim is based on any discrimination or unreasonable action. Full stop. The only claim of the petitioner is that there was about 4 months from the date of the minutes of the selection committee till his retirement, when the petitioner could have been promoted to the post of section assistant. Full stop. It is, however, not the case of the petitioner that any person junior to him in the gradation list was given promotion in that period. Full stop. The claim of notional promotion on the ground that there was a recommendation, there was a meeting of the selection committee prior to such retirement would not be an acceptable proposition, in as much as it will open a floodgate of cases wherein a floodgate of cases. Full stop. Even otherwise, there is no instance which has been pointed out by the petitioner of any junior persons in the gradation list giving the benefit of promotion at the time when the petitioner was still in service. Full stop. The document which was annexed to IA 1184/2022, which was disposed of on 9/5/2022, is of the year 2022, is of the year 2022. That is much after the date of retirement of the petitioner in service. Full stop. The appointment of the incumbent who junior to the petitioner after retirement of the petitioner cannot be a ground to consider to grant notional benefit and subsequent notional promotion and subsequent benefits to the petitioner. Full stop. There is absolutely no dispute with the proposition that a fair consideration for promotion is a right of an employee. However, full stop. In the instant case, it does not appear that the petitioner was deprived of any such right, as in view of the fact that no unreasonableness or arbitrariness appear from the exercise of promotion from the final gradation list prepared on 29/5/2020, followed by the selection committee meeting on 1/6/2020, full stop. In that view of the matter, comma, this court is of the opinion that no case for interference is made out, and accordingly, the writ petition is dismissed.
Obliged. My lord, may I take back the appointment?
এখানে একটা copy করে ফেলি। First page to করলাম। Okay.
Obliged.
Deeply obliged. I apologize.
Come prepared, madam. You are young counsel. Apply your mind.
Obliged, your lord.
Yes, sir, ma'am.
May I
Yes,
please your lordship,
yes.
can the matter may be adjourned for the day, lordship? My senior is suffering from fever, lordship.
Who's your senior?
KUNM, lordship.
Yes,
Thank you,
madam.
I appear for the newly impleted respondent number 7, lordship. We have received our instructions.
File affidavit.
Yes, lordship, we want to file.
And-
affidavit.
My lord, our role is not, this entire pension was on the EPFO. Because they were under 1990 at that time.
Madam, you are for?
EPFO, the newly.
Oh, EPF, okay, okay.
Newly
You will have the role in defending. You have file affidavit.
We will file. affidavit,
You have not
lordship.
filed.
Yes,
Okay,
we have been very lately impleted, lordship,
okay,
and we received our instructions on 6th May, lordship.
okay. Miss A. Chakraborty.
Age of property.
Miss A. Chakraborty, learned counsel submits that she has entered appearance for the newly impleted respondent number 7, the EPF.
Right.
Full stop. She has also informed that instructions have been received based upon which an affidavit in opposition would be filed. Full stop. Sri Sharma, learned counsel appears for the
Respondent number 1 to 6.
respondent number 1 to 6. Full stop. Para. List up to 3 weeks to enable filing of affidavit in opposition.
Obliged, obliged.
As per instruction from my client, my lord, the pension proposal pending before the AG, my lord, respondent number 4, my lord. My lord,
AG.
instruction from the AG, my lord.
So far as that part is concerned, lord, I'll have to get the instruction for that. Lord. But
Get
once-
instructions 21 matter.
I understand.
21.
I understand.
What is your claim?
Claim, my lord, the husband of
Pensionary
the,
benefit,
my lord,
family pension.
M11.
Why family pension? You need time from 21 to 24, 3 years have passed. You're still asking for time. Why?
Lord, I'm just making one submission. Lord, there was some order passed, my lord. Your lord will kindly see 1/3/23, my lord. There was some difficulty because PTC, my lord. Now, once that those documents, I don't know whether what is the.
No, no, you don't want these matters to be pending.
I understand.
If
I understand.
this lady is entitled,
She is. She will,
then
we'll look at
there's
it.
no point even for waiting for a day for pension benefit,
We'll look.
family pension.
Will.
We'll have it on Tuesday next.
Let's
Come up with
oblige.
instructions. Okay. This matter is in connection with a claim for pensionary benefit as well as family pension and is pending since the year 2021 at the stage of instructions. Full stop para. Sri D. Bhattacharya, learned standing counsel, accountant general Assam, praised for some time. Full stop para. As an exceptional case, comma, a week's further time is granted as the subject matter is family pension. Full stop para. List on. It is. Right, we'll have it on 16th. We'll give a week's time. 16th, Thursday.
Oblige.
Okay.
Deeply obliged.
Oblige.
Lord, if hearing this matter, Lord, may I pay for 1 week further time, Lord?
May not
When
pay
my
it to
inspection and file.
2019 years suspended. No
2019?
review, no exhibit matter.
2019?
19.
Yes.
To 26/11/2019, he has been suspended.
Suspension.
Yeah,
Now till now, nothing.
nothing.
What
Please.
is your age, Mr. Ahmed?
is around Lordship 44. Lord.
What was the service you were, what was the post you were holding?
Assistant professor,
Assistant professor?
medical.
Yes,
1 week, Lordship, I'll have my,
what 1 week? Suspension, have
review.
you done a periodic review?
No review, my lord.
Or suspension or pending inquiry?
Then the department, first sheet was issued, my lord.
Oh,
In,
show cause notice issued.
yes, first sheet was issued.
Then,
First sheet was issued on, 5/2/2020. No, to 21, 20/01/2020.
oh, the proceeding has started,
Yes, ma'am.
initiated.
Proceeding started.
Then you have filed response or not?
No, my lord, proceeding has not appointed.
No, after that, have you filed your response?
Yes.
Did you reply to your, the show cause notice?
Yes,
Replied?
replied.
When, which page?
Forty-eight. Under PC Act, he was again suspended, my lord, taking bribe. Written statement.
There's a criminal case.
Yes, PC Act, under
You were arrested
arrested for judicial custody and then suspended.
or then charge sheet filed.
Yes,
You had filed your response on 5/2/2020.
yes. Review for timely review was not.
No, but when was the suspension?
My lord,
Suspension was when?
page 22.
22.
Type 2.
26/11/2019. Six 11/2019.
Directed to file
But this was given within 90 days. There is no lapse as such.
No, lapse. Proceed within 90 days.
You want the DP to be completed?
Yes, DP to be content, my reinstate it with that.
Normally, you come for staying of DP. Criminal cases going on.
Yes, criminal cases. Both cases cannot.
No, both case can go on.
Now they.
No, you have not even prayed for stop holding back the DP.
Not, I have not paid.
Yes, complete the DP. If he's not aggrieved by the continuation of the DP, complete the DP.
Yes, doctor.
He has not even made a prayer for stay of the DP. Even that is not an absolute prayer. In this case of Stengen, I think 1 year maximum.
Yes.
You take instructions.
Yes,
We thought that he was still under suspension. You have done nothing.
No.
And PC Act. And we had also noticed this could have been a relevant factor. Whether you had initiated the proceedings within 90 days, you had done.
Yes.
Sri Upamanyu.
Yes.
D. Upamanyu.
Yes, doctor.
Learned counsel representing the Health and Family Welfare Department. Have got the instructions or not?
No, Lord, I'll send it.
Praise for. And has granted further time of 3 weeks to file the affidavit in opposition. We fix a date, Mr. Ahmed.
Yes.
Let this matter be listed on 1, 2, 3 on 31st of May. File it before then.
Yes, bro. Lovely.
Otherwise, it will go against you.
I'll apply.
21 matter, no response till now.
Matter regarding family pension matter. Earlier also petitioner husband approached side matter, not paid.
Dear Malad, I suppose to
Now
file my
provisional-
affidavit, Malad, but I have received the instruction. I prepared that, but I could not file today, Malad.
Instructions is what?
Instruction is,
Is there any dispute? with
no,
the-
Malad, there is no dispute regarding Malad, family pension, Malad. There is some query was raised by the finance department. We have meet up that query, Malad, and we have sent the file to the finance department. Now awaiting for their response. Malad.
Yes, Mr.
As regards the provisional pension is concerned, Malad, it is released up to April month, Malad.
April of which year? This year?
This year, man.
I have not received provisional pension.
He is saying that only he has not received, but from my instruction, the DEO has released the.
Your lordship may kindly peruse the letter, man.
Have you seen this letter, Mr. Bora?
Yes, ma'am.
I've given a copy to him.
The order was passed on 9/4/2024, last month. Regarding bringing on record, the proposal is sent favor of the petitioner and the queries raised. Finance Department also directed to consider release of provisional pension to the petitioner. Regarding the proposal, man, regarding the regulation, that part not reflected in the letter. Earlier, so many occasions, court had issued of various orders, finally.
Inform you that has been sanctioned in 2/5. 2/5. So maybe within a day, 2/5 it was sanctioned. 2/5, 2024. We are today on 8/5.
8/5.
Maybe within a couple of days.
My lord,
You take
moreover,
instructions?
my lord, lordship may kindly peruse the date, my lord. So, court order has been passed on 9/4 and letter was reference letter was 28/4, my. They themselves making it delay.
Which court order?
9/4 order, last order.
Yes. Okay, heard Sri D. Bora.
But my lord, my prayer is, my lord, in this regard, my lord, earlier court has asked them to compliance of the various orders, my. If necessary, my lord, court can show motu contempt against them, if necessary.
Heard Sri D. Bora, learned counsel for the petitioner. Full stop. Petitioner who has referred to the order of this court passed on the last occasion, that is i.e. 9/4/2024. Full stop para. Sri N.J. Khatonier, learned counsel for the Elementary Education Department, has submitted that a communication has been received. A communication dated 4/5/2024 has been received, as per which the provisional pension up to 30/4/2024 has been sanctioned by the DEEO, District Elementary Education Officer, Sivasagar. Wide communication dated 2/5/2024. And accordingly, the petitioner would be getting the provisional pension for the said period. So far as
Provisional family pension.
Provisional family pension leave. So far as the regular pension is concerned, the learned standing council has submitted that there were certain queries put by the finance department which have been responded to by the education department, and therefore, and accordingly, the issue of regular pension would also be sorted
Regular
out.
family pension.
Regular family pension would also be sorted out soon. Full stop para. You are a party? Sri R. Borpujari, learned standing council, finance department, is directed to instruct his client to take urgent steps for finalizing the matter for payment of regular family pension to the petitioner
And other benefit.
and other connected benefits. Full stop. Sri C. Barua, learned standing council, accountant general Assam, is present. Full stop para. Is present and has submitted that once necessary instructions are received by his office from the concerned departments, the needful would be done as expeditiously as possible. Full stop para. in view of the aforesaid discussions, comma, list this matter. We'll fix a date.
My lord,
List this matter on today's 8th.
early date.
We'll have it on 31st of May. You get instructions, finalize it.
And my
31st
lord, my simple prayer, my lord, they, earlier occasions court had asked them to file affidavit, man. Till that they had never filed affidavit, man, regarding.
Why are you concerned with the affidavit if your
My-
grievance is redressed?
my-
Also,
But I am.
in the meantime, the parties may have also exchange affidavits.
But only one,
Obvious.
only one aspect of the finance department will check for the proposal, but what is there in the proposal. We
Obviously,
will do it. My
obviously.
lord, if they are.
No,
to do-
Mr. Khatronia's submission have recorded that you have raised certain issues. They have answered the issues. If the matter has been finalized,
Right.
if there's anything, you get back to the
Because
department.
then, my lord, there are further shortcomings. my
That,
lord,
that
then
you
my
can
lord,
always point it
I will,
out.
I will.
Always
And regarding regulation part, my lord, they have asked for it.
That have been
Because, my
answered.
lord,
Okay.
the petitioner's husband, he was appointed on advocacy, he died as such. So there was no regular, that is the technical difference. Anyway, my lord, I will.
My lord, they have processed it, they have therefore, by stating the
Okay,
affidavit.
okay.
Obliged.
My lord.
Sri Bora would also take instructions on the aspect of receipt of the provisional family pension.
Obliged.
11 to 15.
May prevalent whether relate to non-payment of retirement benefits, there is gratuity and leave and test.
My
I
lord,
retired
today
on
I am going to file my affidavit. My lord.
Madam, you are for soil conservation.
Yes, my lord. For respondent number 1, 3, 4, and 5.
Heard Sri A. Bhattacharya, learned counsel for the petitioner. Petitioners in these cases, full stop. Miss R. S. Deuri. R. S. Deuri. Learned standing counsel, soil conservation department, however, submits that the affidavit in opposition are ready. Affidavits, huh? Affidavits in opposition. Yes, affidavits में आएगा, opposition में नहीं आएगा. Are ready and would be filed within a couple of days. Full stop.
Today.
Within a couple of days. Full stop. Para. List after. List after 3 weeks. Full stop. In the meantime, Ms. Sri Bhattacharya, the learned counsel for the petitioner, may take instructions on the affidavit in opposition so filed.
Can it be?
List on 3rd of June.
Obliged.
16. Yes.
May I please, Judge Lordship? Lord, matter relates to my lord, pension. Lord, I was initially paid, but I am entitled from November 2019, my lord.
You have retired as what?
No, my lord, my husband died, my lord.
Family pension.
Family pension.
Okay.
And thereafter, my lord, my as a wife, my lord, I am entitled to the family pension from November 2019, my lord. And
Paid from when?
my lord,
Paid from?
paid from my lord, from April 2020, they have paid, my lord.
That period, November to April, you are.
I have not been paid, my lord.
That period you are asking for.
Asking for, and secondly, my lord, what they have done. Immediately after, from the month of May, they have alleged that some wrong fixation was there. And they have started deducting from the, my lord, meager pension, my lord, family pension. And therefore, my lord, this honorable court was pleased to issue notice, my lord, and stay the further recovery, my lord. But no affidavit till date, my lord.
But the recovery has been stopped.
Recovery has been stayed, my lord.
That recovery part is within the domain of which department? AG,
Home Department.
Home Department. Madam?
Department has not.
Lordship, in part, Lordship, for recovery, Lordship, there is a specific direction from the administrative department to recover that lot.
But that has been stopped.
Yes,
now.
Lord.
You filed your affidavit.
Mild.
So far as part is concerned, there may not be any urgency. That 4 months, though it is a important matter, why
Right.
should one be deprived of even 1 month?
Mild.
But since she is getting the family pension, you file your affidavit. Who will file? Both.
Let's put.
First, we are learned counsel for the petitioner. Full stop. Para. Both Sri R.K. Talukdar, learned standing counsel, accountant general Assam, as well as Miss M. Bhattacharya, learned additional senior advocate Assam, pay for and are granted 3 weeks time to file affidavit in opposition. Okay.
But may I pray for a
List
date?
on 3rd of June.
Right.
17. Yes.
May it please your lordship. My lord, respondent, higher education is yet to file the affidavit, lordship. Lordship's matter came
What is the
upon,
subject matter? What is the subject matter?
lordship, this, I am lecturer, senior scale. I have to get selection grade scale, lordship. My prayer is that, lord.
Okay, Mr. Tobildar, you for education department?
Higher
Higher-
Hello.
We have missed them at it.
Okay, we'll have it on Friday. Get instructions.
Yes, sir.
You may have some instructions in the file.
Yes.
If you require more time, we'll grant you time. Friday, you bring the file.
Friday.
Okay,
Lordship, next week, lord. May I pay for next week, lord?
next week. Okay, next Wednesday.
We'll look into it.
Okay. On the prayer made by Sri Tahbildar, learned standing counsel, higher education department. Matter is adjourned to be listed on 15th of May.
File.
Your name shown or not? Your
Higher
name
education don't look, but we have missed, somehow we have missed.
Yes. Did you have 15.5? Item number?
18, madam.
Yes, instructions?
No, madam.
No
First
instructions.
time listed after 21, madam.
Why? Why no instruction? None appears for the petitioner on call. Para. Sri N.J. Khatanir, learned standing counsel, elementary education department, prays for and is granted 3 weeks time to obtain instructions / file affidavit in opposition.
Obliged.
Item 19. None appears for the petitioner on call, whereas Sri D.P. Bora, learned standing counsel, health department is present. File affidavit.
My lord, activity of not, actually, they are claiming for benefit under the case of Upendas, my lord. They are employee under the.
Okay, in the interest of justice, list after 2 weeks.
Obliged.
20. 20. Mr. Sinha,
One time every kilometer.
For?
Reply,
reply.
Yes, ma'am.
Affidavit was filed when?
Long ago, but I'm like,
2021, you need further weeks time for what you could not do in the last 3 years. How can you do in 1 week?
only 1 week time every given, only 1 week.
You could not complete in 3 years.
No, on the last year, on the August or September, they have filed a position, by the finance, finance is the main, my lord. Finance affidavit has come only on
Only on August of which year?
of 2023, my lord.
And wherein?
We are in May, only one week time. Still not, my lord.
Here for whom,
And
madam?
for the department, your lordship, response number 26.
Which department?
Corporation department.
Cooperation.
Okay.
Finance is the main, my
Finance
lord.
is the main, your lordship.
You're not filing affidavit of,
We have filed, your lordship.
no, no, you're not filing reply.
No, against the department, my lord. Finance we have to file.
Okay. Heard Sri B. Sinha, learned counsel for the petitioner, whereas the Corporation Department, where is Matlaki? Full stop. The Corporation Department is represented by Miss S. Waqt, whereas the Finance Department is represented by Sri R. Bor Pujari. Full stop. Para. Sri Sinha, the learned counsel for the petitioner, prays for a week's time, prays for some time to file the rejoinder affidavit. Full stop. Para. List after 2 weeks.
Yeah.
2 weeks.
Obliged,
you have to
obliged,
file. One
obliged.
bonus week.
Obliged.
Okay.
21.
May I pray for time being. Senior on legs import too.
Timing is not possible, madam, today. A lot of matters, 50 something matters. What is the subject?
Grant of MACP benefit.
Okay. What is your take?
Lordship, our
Are you
replies that
objecting?
yes,
Objecting?
because of low medical category and also because of his depression and all.
Depression?
He did not fill the benchmark and all.
What
Lordship,
depression?
I'll be relying on one decision in which Supreme Court said he has to file a representation. That has to be considered. Lord. That can be done, Lordship. He has filed a representation that can be disposed of.
Yes. Madam, what do you say on your senior friend's response?
My lord, I pray like that my senior I pray for.
You're not very confident.
My lord.
You seem to be confident, smiling, not nervous. Yes, let Mr. Mazumdar come. We'll follow that.
Okay.
Yes, next.
Lordship,
This was
item,
mentioned,
yes, Lordship.
but one of the party was not informed, so we
Yeah,
sent.
item number 24.
Lordship,
Court of Bishop.
Lordship, the issue in this case is lordship pending before the honorable. Supreme Court. If I may,
Okay.
it was last listed on 27.
Issue, same issue. Are you aware?
This Ravendranath Sharma appeal was allowed here. We have challenged that.
Okay. Sri R.K.D. Chaudhary, learned Deputy SGI,
Lordship,
submits
sir, advocate here,
for whom? Oh, you said also.
Assam Financial Corporation.
Oh, learned counsel for the
Assam Financial Corporation.
Assam Financial Corporation submits that the issue involved is presently before the Honorable Supreme Court in the case of
SLP number 1019581 of 2023.
019581 2023. Name
Assam Financial Corporation versus Ravendranath.
Assam Financial Para. In view of the aforesaid submission, let this matters be adjourned by 4 weeks. Full stop. The learned counsel for the parties are, however, given liberty to make a mention in case there is a disposal of the matter before the Honorable Supreme Court in the meantime. Huh? 01 SLP number, please.
SLP number is 019581 of 2023.
Oh. R6, you are AL Mondal.
AL.
Who's R6?
LIC.
LIC. Oh, AL Mondal Learned Council is present for S1 number 6, just LIC. Let it be 6 weeks, not 4 weeks. Because now now there will be a vacation. What is the point? 2 months.
Yes.
2 months. 2 months. Good.
Majumdar is
Yes.
21.
But I would not dispose of it. But yes, my lord, what has happened is here that we are agreed by the below benchmark gradings given by the respondent authorities, due to which I missed my MSCP benefits. I had made a representation to the respondent authorities. Now, Lordship would kindly find their
Now what has
response to
happened?
that.
Considered or not?
No, what is, they say we will not consider it because it is useless. Lordship will have page 56.
Will not consider it because?
What they say is you are below good. Even if we consider, you will become only good.
Okay.
So only good is not the benchmark, very good is the benchmark.
Okay.
Therefore, nothing remains in your representation. But how, before even considering my representation, they say that I will not be elevated from below good to very good. They say that we will only elevate you with one step only to good. First matter that would not be justified. They have to go through my service records before they come to a finding whether it has to be very good or good.
Now that is within the domain of whom?
Their domain.
No. There is a very vague and large thing. Who is the authority who would assess your gradings? Whether you are good or very good or that there has been an error, who will consider?
But the reporting authority and the reviewing authority or the accepting authority, as the case may be, has to assess my performance.
Now this affidavit has been filed by whom?
This affidavit in opposition has been filed by not those persons, but by others.
No, other.
By the DIG.
DIG, he is on.
He is neither my reporting authority nor my reviewing authority.
No, normally who is stated group center in charge.
No, he would definitely file not on his personal assessment. He would file on the basis of official
instructions. Yeah. Now, in the affidavit, they did not say so, my lord.
Now,
Say so in
will
my-
it really serve any practical purpose or effective purpose?
My lord.
If they on affidavit, the organization as such has come to a conclusion that at best you can become good.
My lord, that is what, that if that conclusion is interfered with by this honorable court on one ground, that the benchmark having been elevated to very good. Now, my lord, the term very good or bad, my lord, it's settled position of law that does not matter much. It is what is the benchmark. Anything below the benchmark is adverse to me. Now, when very good becomes the benchmark, for them to give me something below the benchmark, they must have a reason. Now, that has not been taken into consideration.
Now,
by
are
the
you
respondents.
questioning the fixation of the benchmark? That is not the subject
My
matter.
lord,
of- Benchmark
what
is
I
very
read
good.
is, when I was given the remark, good was the benchmark. 1 year later, very good becomes the benchmark.
No, but on a very practical side, facet. What at best you can direct them to consider the representation.
Yes, my
They'll
lord.
simply
And
they'll simply reject it. We have already made our position very clear in the affidavit.
if they have to consider my representation with a judicious mind, they have to give a reason why I will be below the bench. The ACI, if lordship, I have annexed the
Affidavit
ACI.
has not, nothing has been stated in the affidavit.
No, why I was given below benchmark, they have said that I was mentally depressed and therefore I was not being used for combatant duties, therefore I am below. No, that cannot be. Whatever duties were given to me, if I had done that properly, I cannot be below benchmark. If I cannot do a certain duty because of
How will you assess a particular cadet to be above the benchmark or not? Court will have a very limited
Well,
role, will not like to go in. These are the matters of their satisfaction. How
Well,
can we say sitting here?
And the Supreme Court has been Supreme Court has been clear on this point that when a person is being denied any service benefit due to a remark in the ACR, then that remark has to be justified. Lordship will have the APR for a moment, my lord. They say I was totally satisfactory, and then in the remark they write below good or good. That remark is
Mr.
effective.
Mazumdar, you know the scope of judicial review. We
Well,
can only see whether the factors they have considered are relevant or not. We
Exactly,
not
ma'am.
go into the
If
adequacy or the merits of the
Lordship will find
consideration.
if Lordship will
If we
find
find those are relevant, Nothing doing, if
If
we
lordship
find
will-
that some extraneous circumstances, extraneous factor, the irrelevant factors have been considered, then yes, you may have a
But
case.
if it is without, if it is in the absence of reasons, then a below benchmark grading has to go is also
No,
what the Supreme Court has
It's
said.
not
my lord.
absence of reasons, you are on the adequacy of reasons.
No, my
You may
lord,
not
I am
go
on the
to-
absence of reasons.
They have said that you are mentally found depressed.
A depressment, my lord, is not a
This is
reflection of
not
the
the
performance
absence
of
of
work.
reason, this is the,
When
you
the
may
per-
say this is at best adequacy of reason, you are
The-
questioning that this
My
is not enough.
performance is said to be satisfactory. But the below good comes because I have a medical problem.
You file affidavit.
They have filed a.
We'll like to hear this matter. If you want, you can file your rejoinder. Would you like to file rejoinder?
I'll file a.
File your rejoinder. Matters need to be considered. Sri B. Chakraborty, Learned CGC submits that affidavit has been filed in this case long time back. What's the para? Sri R. Mazumdar, Learned Counsel for the petitioner, submits that one further opportunity may be granted for filing affidavit in reply, full stop para. In the interest of justice, list after 3 weeks to enable filing of rejoinder affidavit. File it, 21 matter, will consider.
23.
Yes, what is this?
Here the defense of the petitioner is the non-payment of risk allowance, which was supposed to be paid to him. my lord,
Yes,
for the
yes,
period
Mr.
he-
Gogoi.
Lordship, as per our affidavit, he is not entitled. When this was decided by our High Court also, as well as Honorable Meghalaya High Court.
But, I am not aware of the reply.
I will
If
give
I
him
can have
the
the judgments, my lord, if it's covered, we can let it go.
Sri K. Gogoi, Learned CGC, by referring to the affidavit in opposition filed on 26/4/2022, has submitted that the entitlement of the petitioner cannot be, and that the claim of the petitioner cannot be granted as the same is not legally tenable, full stop. He has also submitted that the issue has been settled by this court as well as the Honorable Meghalaya High Court. Full stop para. Sri Mazumdar, the Learned Counsel for the petitioner, prays for and is granted a week's time to obtain instructions. Full stop para. List on Thursday next. We'll dispose this of. List on 16/5 for admission hearing.
Yeah.
26.
My lord, here in this case, my lord, for one advance agreement, my lord, for B.Ed degree, obtained, my lord, before prior to 2012. My lord, I was directed to file, my lord, the document, whether, my lord, if I have a-
Can I go ahead with this matter?
No, well, I have received the instruction, so I want to bring it on record, my lord.
You have filed something. Or you have not filed anything. These are additional affidavit.
filed by me.
Additional affidavit filed by my
Filed by
lord,
me.
my lord.
Let him file it.
Yes.
Sri N.J. Khataniya, Learned Standing Counsel,
Secondary division.
Secondary Education Department, submits that instructions have been received and he would like to file an affidavit in opposition, full stop para. Considering that this writ petition is of the year 2021, comma, 3 weeks time is granted for filing the same, full stop. List on, we'll fix it. All matters. 1, 2, 3. List on 3rd of June.
My lord.
You're getting enough time, file it
Yes, my lord.
immediately.
Obliged.
Item 27.
27.
May please, Lord.
Tarudan?
But a matter is for non-payment of area salaries leading to the service of my husband, Lordship. Here in this case, Lordship, the finance department has already clarified their stand in the last occasion, Lordship. And in this regard, Lordship, two affidavits were filed. One was filed by respondent number 5. And other is filed by respondent number 1, Lordship. And their stands are, Lordship, contrary to each other, Lordship. The Lordship, but fact is that in the year 2007, 10 numbers of persons were appointed by the council in sanction vacant post and following due process of law. But they were not paid their salary, for which a chain of litigation shall.
Yes, what do you say, Mr. Nayak?
Lordship, so far as the first salary is concerned, Lordship, the appointing authority needs to submit the first salary proposal to the PIN-Assam portal, Lord. And so far as the instruction received from the finance department, no such proposal was uploaded because of the lack of information or lack of relevant documents.
By the NCLs council?
By the NCLs council. So stand of the NCL will be.
Madam, NCLs?
Not for the affiliated
No,
department.
no. Madam, you're for NCLs? Who's your senior?
Lordship, proposal were for 10 persons, Lordship. Proposal of 9 persons were accorded by the finance department, Lordship. Only my husband's proposal were
Okay,
left.
let Mr. Das come, we'll see. Call him. Yeah, attack is very good. Mr. Nayak, we had looked for you in one of the matters, which was. We're going to get it, one item. We. 5, who was there? Mr. Vishwakarma, you were there in 5.
For the respondent wanted.
Okay, what was the matter? We wanted his.
Yes, my lord, actually salaries were not being paid up even after the retirement, the engagement salary. And we said that we were not having fund. As a result, we
Okay, yes. The funds would have to come to you from you.
Not.
Some salaries.
Report has a standing top. That's 6.
No. SP should.
SP should do it.
I'm on.
No, he says that the funds have not come to from you.
It's a principal for the board. So they should have their own funds, not from the government. So in any case, not to be to who is the party there, that definitely I think.
No, you get the instructions. Which item number?
Item number 5.
5. You লিখিছিল নেকি আমি?
My lord.
So?
My lord, as per order dated 11/4, my lord.
The matter pertains to our claim for leave salary encashment of the petitioner who had retired on superannuation as public relation officer on 31/1/2019 from the Assam Urban Water Supply and Sewerage Board. Full stop. The yes. And that matters the answer. For the present 23-24, you have not proposed. You have to make a proposal.
My lord, but from the year 2022 itself, we have given the proposal for that. And after that, there is no response.
क्या लिखा? Mr. Kyle. Mr. Kyle. Your matter. The stand of the government has been made by way of an written instruction. So the government is not responsible for the payment and otherwise of the board's employee. And at times the grants are given. Grants were indeed sought for the year 22-23, which was not accorded. But in the present year, no such proposal has been given for 23-24.
And the board has its own resources of revenue, they are collecting revenue their own. There are many projects in different districts of state of Assam.
That is the stand of the state government.
Yes,
Board generates its own income and they pay the salaries from the income generated. At times grants are given by the government, but that is not dependent. Your salaries are not dependent on the grants of the government. What do you do, Mr. Verma?
I think we need to have some instruction regarding that.
क्या लिखा last में? ये तो लिख दी हाँ और उसके बाद from the affidavit in opposition filed by the respondent number 2, the board, on board on 23/8/2021, it appears that the stand of the board is that funds are not made available by the government, as a result of which the claim of the petitioner has not been able to be taken care of. Full stop para. Ms. M. Bhattacharya, learned additional senior advocate, has however placed on record a copy of the written instructions dated 9/5/2023, as per which, the responsibility for payment of salary and other retirement benefits to the officers and the employees of the board are entirely with the board and the government has no role. Full stop. It has further been submitted that though the government provides grants in aid, there is no proposal for the financial year 2023-24, full stop para. Let an affidavit be filed based on the aforesaid instructions by the department, full stop. The learned counsel for the board is also directed to take necessary instructions and also steps towards forwarding the proposal for grants for the concerned financial year 2023-24. You have a copy, madam?
Yes, sir.
List on 3rd of June.
Yeah, please.
Yeah, number. WPC 71.
Item 28.
This is your lordship.
Yes, madam.
Lordship, the matter pertains to area salary of the petitioner, your lordship. The department has not filed the affidavit.
Lordship, I have instruction, Lordship.
Area salaries as what?
Lordship, the petitioner, she was initially appointed in a school at Nalbari, your lordship. Thereafter, she was transferred to Mongoldoy. Lordship, due to some matrimonial issue, she had submitted representations for her transfer to a different school. Thereafter, she was attached to a school at Borpeta, your lordship, in the year 2007, your lordship.
You are still in service, madam?
Yes, your lordship.
You are still in service?
Yes, your lordship.
Okay. Which period you have not received salaries?
Lordship, from March 2018 to February 2019.
Almost a year.
Yes, your Lordship.
What is your instruction, Mr. Sharma?
Lordship, the press proposal has been directed to be submitted by the DEO. Lordship. So once that press proposal is received,
But you have filed your affidavit in opposition otherwise.
otherwise if a file.
You are not
earlier-
denying the claim as such,
No,
I
Lord,
think.
no, Lord.
Okay. Okay, let some time, we'll grant some time. There is a recent communication, 6th of May. Okay. Heard. Miss P. Hazarika, Learned Counsel for the petitioner. What's the para? Sri P. N. Sharma, Learned Standing Counsel, Elementary Education Department, has however submitted that towards redressing the grievance of the petitioner, the Director of Elementary Education Assam has issued a communication dated 6/5/2024 to the District Elementary Education Officer, Kamrup, whereby a fresh arrear proposal along with relevant information documents in the prescribed format was directed to be resubmitted. Full stop. Para. Sri Sharma, Learned Standing Counsel, submits that the necessary formalities would be done expeditiously. Full stop. Para. List after 6 weeks. We fix a date. Salary matter. List after six weeks on today's 8, so 1, 2, 3, 4, 5, 6 on 21st of June.
Okay.
I think 27 timing.
Yes, yes. And sales matter. When was it sent?
Lordship, in our affidavit, we have stated
When was it sent?
In the year 2019, Lordship, along with others, Lordship.
for others, we have received an
Out
accordingly, we have
of 10, 9 out of 10 Lordship has already received.
and we have paid.
9 has received out of
9 has
10.
received.
You are the one left out.
Left of Lord.
Yes, he was. His name was also.
My instruction is here.
His name was not uploaded, Lordship. So far, their instruction is concerned.
Who will upload it?
Council has to.
Hill areas department, that is not ours, that is the government.
Hill areas. Madam? No, if it is a matter of formality, some uploading in the Fin Assam, you upload it.
Lordship, in the affidavit filed by the department, Lordship, one specific paragraph is here. The principal secretary and Civil Autonomous Council has submitted verification by letter number so dated 28,019. Also uploaded on financial portal number that the information proposal of late Boru Plankasa were not uploaded due to unavailability of relevant documents. So that is the stand of the department.
Okay.
And that is why we have given.
Who will give the information to the?
Sorry.
Mr. Das, you have to
Yeah.
feed
You
them,
have to submit it
feed
to
them
the-
with some
Yeah, yeah.
documents and information.
Yes.
What are the documents lacking, madam? If you can specify, we'll ask Mr. Das to.
Yes, Lordship, I will.
Please tell us what are the documents.
The information of the were not updated. Of relevant
What are the documents?
that
After that,
para one. Under office of the accordingly, the same was submitted by our online file number students who dated 75/28 for 9 numbers of income tax excluding late or time.
This is the instructions of 2019 Lordship, and we have filed our activity where we have said that we have already uploaded.
And Lordship,
Where is your affidavit?
Finance Department accorded Lordship in the year 2020, Lord.
We have filed our affidavit on 15/2/23 Lordship. By respond number 5. Lordship.
What have you stated?
Lordship, paragraph 7 Lordship.
Please read.
That with regards to the statement made in paragraph 3 of the writ petition, the answering deponent begs to state that the deceased husband of the petitioner, Orup Lantasa, was appointed as Jupiter in the office of the executive engineer PWD RNB Maibang by office order dated 30/4/2007, issued by the executive engineer PWD Maibang. Accordingly, he joined on 30/4/2007 before the assistant executive engineer PWD Maibang, and the same was forwarded to the office of the executive engineer PWD RNB Maibang on 7/5/2007. The paragraph 8, that with regards to the statement made in paragraph 8 of the writ petition, the answering deponent begs to state that the deponent has submitted a proposal for sanction of payment of arrear salary of the deceased husband of the petitioner before the respondent number 4, Principal Secretary NC Hills Autonomous Council, Haflong, White letter dated 26/4/18. Accordingly, respondent number 4 had forwarded the same to the Deputy Secretary HAT Dispur, Assam, White letter dated 2/5/18 for onward submit.
That was 18.
18.
No, thereafter there is an objection that some information, some details are left out.
Then in paragraph 9, Lordship, we have stated, Lordship, the answering deponent begs to state that the arrear salary proposal of the deceased husband of the writ petitioner was returned with observation, and the deponent, after mitigating all the observations, resubmitted the same, and finally the finance SIU department, by letter dated 7/7/20, accorded the approval of 9 new appointees. In the said approval, the name of the petitioner's husband was not indicated, though in the proposal, his name was also sent to the finance SIU department for approval.
Not finance.
Finance is not controlled by the demand.
Okay, they have their own asset. We are another under state law.
Dimahasa has a separate SIU.
No. One finance asset which they also have, which we also.
No. We don't
So
have-
in any case, not my instruction is dated 19 March 2020. So it's up
How
to
can there be an SIU in Dimahasa?
No.
We have not heard for a SIU. SIU only with the state government's finance department.
They have one. They first within the council aid.
We don't have any. Finance is totally controlled by the.
In the instruction, Lordship, I have
Mr.
just.
Das is denying. How can you say that there is an SIU?
No,
in the
Lordship, that is not an, not, if it is.
If issue or not, why do you make such a statement? SIU is in Dimahasa. We have never heard of an SIU in Dimahasa. We know something about this Dimahasa. Tell us where is an SIU? We record your statement.
On that issue, Lordship, I will clarify that I will place the necessary. So far as the present.
What steps are you taking for addressal to ameliorate the grievance? It's a very small issue. Whether uploading the information or not, he says he's uploaded. You said you have not uploaded. He has given subsequent communication.
Mentioned about this also, Lordship.
Okay.
Yes. So there also, we have said, cover the principal secretary NHS has submitted verification and letter number dated 2019 also uploaded on some portal that the information proposal of were not uploaded into unavailability of the documents. As was resubmitted to Finance Excise Department on 18/5/2020.
Correct.
Finance Excise Department accorded the approval of 7/7/2020 for 9 numbers of endowment. This is their launch. This one also we have stated in our. This 7/7/2020.
Paragraph 10 of our affidavit, we have also already stated, that if the Lord permit may read the answer.
Right, change of affidavit is not very material in this matter. We want action from your part.
Yes.
You're not disputing the claim as such. If you're disputing, matter would have been different.
We have already sent the proposal to the finance SIU department. Lord.
They cannot send it directly to SIU, it has to route it through hilarious development. And they are saying that annexure B lot of that instruction of the exhibit filed by the hilarious department. It's clearly mentioned, PWD engineer, he has forwarded proposal for 10 numbers, but the hilarious department submitted 9. Annexure B lot, it is dated 2nd of August 2019. Only 9 were up.
Let us see the approval.
We grant 2 weeks time to obtain concrete instructions as to which authority is required to act now. Mr. Das, you also took instructions, what kind of additional information which were required by them were given to them, which did, what are the information? Why 9 were paid and why the petitioner was left out? The present claim raised by the wife of a deceased employee of the Dima Hasab of the NCL's Autonomous NCL's Council, NCL Autonomous Council is for area salaries. Full stop. The pleadings exchanged so far would, however, pleading exchange so far as and from the submissions made by the learned counsel for the various parties would, however, reveal that there is some controversy with regard to the proposal of the husband of the petitioner pertaining to all necessary information. Full stop para. While the council CIL, NCHEC has submitted that the proposal of the petitioner, the proposal of the husband of the petitioner was also sent along with the 9 other incumbents, the version from the finance department and also the concerned hills areas department are that certain information was lacking. Full stop para. Considering that the claim of the petitioner as such is not a disputed one, and in fact, there is an earlier order of this court, and in fact, there was an earlier proceeding in this court, namely WPC 6231/2014, this court is of the opinion that the above situation
should not be a reason for further delay in release of the salaries to the petitioner. Full stop para. Let to resolve the issue, comma, let concrete instructions be taken in this regard by all the learned counsel appearing for the respondents. Full stop. Instructions, comma. Instructions from the NCHAC is to be on the aspect of the information and date regarding the petitioner which was proposed along with the 9 other similarly situated persons to the concerned department. Full stop. The Hills Areas Department represented by Ms. M. Bhattacharya, learned additional senior advocate, as well as the Finance Department represented by Sri Nayak P. Nayak, the Learned Standing Council, are also to seek instruction on the aspect as to what information was remained to be uploaded in the FinAssam portal for completion of the formalities. Full stop. Para, list on. We'll have it on 27th. 27th upon 2 weeks. On 27th. 27/5.
Ablash.
29.
May I please Lordship, the matter relates to non-payment of family pension and plus release of arrears salary since October 2011. The husband of the petitioner herein was
Which file, madam?
Lordship, we have filed our affidavit.
Irrigation Department.
Lordship. Affidavit.
What have you stated?
Paragraph 4 of the affidavit, Lordship, running page.
Are you disputing the claim?
Lordship, in fact, Lordship, another wife has filed an appeal against the order because
Oh,
pending
madam, you're the
before-
second wife.
third wife.
Third wife.
And the another wife is not a party here, Lordship.
Okay, it's permissible, but permissible for the marriage, but whether it's permissible for receipt of post-retirement benefits?
Yes,
I don't,
Lordship.
which decision?
Which
Decision. Are you entitled, the second wife, third wife?
What?
Are you entitled to post-retirement benefits of your husband, second wife, third wife?
Yes, Lordship, I'm entitled. Plus, we have already
Entitled
released
as
half
per
of
which
the certain
decision?
percentage of the amount.
Which is the decision? You do not know.
Yes,
What is the basis of your claim? You are the third wife.
I'm the third wife, and they are stating that he is not divorced when
She is not?
divorced. The second wife was not divorced. And
Now, are you claiming that you are the lone existing wife?
yes, Lord.
Lone existing. There is
If
no.
not, second wife is present, divorced, and she
If
remarried
it
to
is divorce, she
another.
is not the wife.
Yes, Lordship.
Divorce
Plus-
is not divorce. If there was a factum of divorce.
Yes, Lordship.
There was.
She was
So you are
divorced.
the existing wife, not
Yes,
the third
Lordship.
wife.
Yes, Lordship.
You must have
Plus-
been the third time he had married, but you are the only wife.
Yes, Lordship.
That is your claim.
Yes, Lordship.
Now,
In the service-
what do you say?
Lordship, paragraph 4 of my affidavit.
What have you said?
That as regards the instructions pending in paragraph 3 of the writ petition, the answering respondent back to stated the writ petition, present writ petitioner filed a succession case before the learned district judge, Dhubudi Bhai Tagnis, SC case number 52/2012, and by judgment dated 13/12/2016, the learned court below disposed of the aforesaid Miss SC case number so and so. The opposite party of the aforesaid Miss SC case number so and so, that is another wife of the late Abdul Batan Sheikh, namely Noor Jahan Khatun, filed a first FAO, filed FAO number 10/2017
Okay.
against the order dated so and so.
Oh, who is Noor Jahan?
Second one.
Second wife, Lordship. He has filed an FAO.
She is not divorced.
She is divorced. She got divorced.
is not a
Lordship.
party,
We have
her
annexed
lordship,
the
that-
document.
She is not even a party here. You want a walkover, madam? Walkover is not permissible.
How is pending before this court, Lordship, for the application?
Why haven't you made Noor Jahan a party? This is not a fair practice, madam. You don't disclose anything.
Lordship, the power has not been disclosed even, Lordship.
Have you revealed that you had filed a succession case? Even that you have not revealed.
Succession case has been disposed of, Lordship.
Have you revealed?
In the writ petition, Lordship, there is no whisper, Lordship.
Then how do you file this writ petition? Madam? What is this?
Additional affidavit.
Hmm?
Can I file one additional affidavit?
You had filed additional affidavit. What have you stated?
No, he want to file, Lord.
You want to file additional?
He want to file additional. Right.
What has happened in the first suit succession case? What orders?
I have annexed the order, Lordship.
You have filed affidavit.
I file it.
Where?
Lordship, the affidavit filed by the executive engineer, Lordship, Ratul Goswami, Lord.
Yes.
Annexer A is the order passed by the Lordship District Judge. This filed in May 23.
This is gross suppression, madam. You have to pay cost. You have to pay heavy cost. The council also have to pay cost. Cost will be imposed on the council also. Same council. Council is equally responsible, madam.
Call Mr. Biswas. Call Mr. S.A. Biswas.
And Lordship at 2 midnight.
2 o'clock. Ask him to be prepared on the cost part. Cost of the party, cost of the council. In very exceptional, rare cases, we hold the council to be responsible. This is maybe one of the cases.
Apply.
So the petitioner mother, while serving as senior manager in UBI, at that time she died and he was.
PNB, I think there's a standing counsel, Mr. A. Ganguly. Where is he?
See.
Please inform him. A. Ganguly and some Mr. Pushilal or whoever. Or is it Ganguly? Follow this up. Yes, so what is it, Mr. Andy?
Post the judgment passed by the division bench with Penta, he is in grievance that is not getting the minimum of fix.
What do you say?
But as such, can be disposed of with a direct to the commissioner by the service records of the petitioner.
Well, let him come. None appears for the petitioner on call. Whereas the Department of PNRD is represented by Sri P. Hendik. Mr. Borpujari, also there.
Fine.
And the Finance Department by Sri R. Borpujari. Full stop. Para. In the interest of, this is a matter of 2021. Full stop. Para. In the interest of justice, let another opportunity be granted to the petitioner. Full stop. List this matter on Friday next. ये Friday. या on Monday कर डालिए. ना Friday करा दीजिए. Friday next. ये वाला. नहीं ये वाला. This Friday. On 8 कैसे होगा? 10th. Full stop. It is made clear that in case of further non-representation, comma, appropriate orders would be passed.
Thank you.
Here also the issue is one of payment of the minimum, which is under the open case. The name of the petitioner had been forwarded and approved by the finance department for payment of the minimum scale mallet for open. Thereafter, when he was not being paid the wages mallet, they passed an order on 11th of July 2022 saying that there will be an inquiry because for the department, no one was engaged after 1/1/1993. Pending that, my lord, we had approached this honorable court that already our names had been forwarded. We were already entitled to it because of the 10 years of service and we should be paid. In their affidavit in opposition, they admit that we had been engaged by them. As a matter of record, they bring in my lord at page 35. They say these are the 3 persons, they were appointed in 93, 94, and 95, and therefore they were appointed. But there is an inquiry going on. Now, my lord, with an additional affidavit, they have tried to show that these persons were, there was no one appointed after 1990. Already, my lord, once my name being sent to the finance department, already there being approval for that. On the basis of
No, if your entry is after that particular date.
There is no particular date of entry as such, my lord. What Upendas that held was those who had completed 10 years of service would be entitled to a minimum scale. They admit in their affidavit in opposition that yes, I am completely, I am still serving.
Let us see Upendas 45. Upendas was नहीं रखा. WA 45 or 11.
Windows Square রাখিয়ে তৈরি বলে বলছি।
Have to count it, my lord.
Yes.
Retrospective of the date of judgment.
Yes. Yes.
Yes.
That I also agree. And the stand is that from the date of the judgment, my lord, I had my 10 years of service.
This is of 2011, isn't it?
Then that's my lord.
Oh.
17, from 17, it will be complete 10 years back.
10 years
So 1997, admittedly by their affidavit, I was.
17 is not 10 years, 97, 2007.
2007, I was appointed by their affidavit based on records 93, 94 and 95. That is very sensible. And finance has already given, my lord, that the approval has already come, the sanction has come. They have not revised it, nothing.
The inquiry was held in that we have stated that they were never.
Now this, Mr. Borpujari, this this direction had come from a concession made by you. It was not keen to or following strictly Umadevi. Umadevi had said something else. But you said that no, that since they are working for more than 10 years, we will form a scheme to give certain minimum pay. This has come from you, and therefore the division bench has endorsed the state submission. That's a concession. Now, if you say that he has met the concession by having served more than 10 years prior to the judgment, then what is the hurdle?
They have, finance has given it to me.
So, the finance department is the nodal part. Now, my lord, the proposal has to come from the concerned employer.
Now, whether an inquiry is held or pending, will that be relevant? No, are you raising a question that he did not complete 10 years prior to Upendas? Are you raising that question? You are not raising the question.
So I denying on the exam in of 20 to 22.
10 years.
10 years.
No, are you saying that he did not have 10 years?
It is for a.
Yes.
for the employer.
Yes.
They will not.
Yes, so what are you saying, Mr. Sharma? Are you disputing the proposition of fact that they did not serve for 10 years prior to Upendas?
Order on tax and inquiry was held. Yes, inquiry order was signed at page 29.
What does it say?
On inquiry. page
Okay, we'll come back. You find that particular thing, whether there is any dispute on the aspect that prior to Upendas 10 years, were they serving? If it is not within the ambit of 10 years, then matter will be different. But if it is if the controversy is not with the question of 10 years, but it may be 14 years, 15 years, that will not be material, whether they were appointed 93 or 94 or 95. If they were appointed till 2007, they get the benefit. We'll concentrate on that. Because this is nothing to do with regulation, nothing, it's only minimum pay. Okay. Okay.
The of the pleadings, lordship would have paragraph 7, page 7, paragraph 5, my lord, of my writ petition. So here I have stated that initially.
You need not go into this. The respondent will just show that they were not in continuous service for 10 years prior to pronouncement of Upendas.
That is what I was trying to show. They have affidavit on record. Lordship.
Is there anything?
That is the affidavit which we have filed, Lordship.
Where? Yes, where?
Lordship, in paragraph 8 of our affidavit, Lordship.
Paragraph 8.
Page number 35, running page number 35.
By one Asif Deb.
Yes, sir.
Paragraph 6 also.
Paragraph 6 is the initial date of their appointment.
Yes, there, then.
There is some corrections, Lordship.
Okay.
Paragraph 8, Lordship.
Yes.
May I read, Lordship?
Yes, 93. Yes, please read.
Lordship, in paragraph 8, Lordship, we have stated that the deponent begs to state that in terms of the order of the Honorable Court passed in the WA 45 of 2014, Upendas and others, versus State of others, dated 8/6/17, the list of existing workers, master roll, and fixed pay workers under East Guwahati West Division Water Resource Department was submitted to the office of the respondent number 4 during 2018.
Mr. Das, that is not enough. After 1/4/1993 is not enough.
Lordship, what what we have find.
You have to come with a categorical statement that the length of service of the petitioners are less than 10 in respect to the judgment pronounced in Upendas. That's all.
Then I take the instructions.
So there is no question of instructions.
Lordship, the thing is that they were working as a master role workers, but the thing is that some illegal appointees were there during that period, because of which means inquiry was conducted.
We are not on the aspect of legality of the inquiry. We are respect of minimum wages.
Lordship, that is what, Lordship. That is what. Lordship.
Minimum wages, Upendra simply said 10 years from today.
Yes, yes. Your Lordship is correct.
And they are saying 93, 94, 95. Illegality, legality will be a different aspect. You draw up a proceeding, terminate them. You cannot deny minimum wages. That's a concession from the state.
Your Lordship is correct, Lordship. But if your Lordship come means the additional affidavit which we have filed, Lordship, there also we have stated that only 11 numbers of master role workers are there. Out of that, 8 numbers are working in Lakhimpur and 3 numbers are working in hydraulic station Guwahati. The names of the petitioners are not there as far the
as on date, working as on date.
Lordship, they are not the confirmed, means they were engaged, the master role workers who were engaged after 1493. The names of the petitioners are not there. That is the inquiry report which we have already annexed in our additional affidavit.
Now, are you making a categorical statement that they were not in service 10 years before the date of Upenda's judgment?
That is not there. That statement is not there. That is
And
what
the gap is not a day or two or a month or a year. They are saying 93, 94, 95. We need 2007.
My lord, at page 7, my lord, I have made a statement that they have been paying my salaries from 2007 onwards in my bank account. Affidavit in opposition, they say it is a matter of record. True, correct.
What else do you need?
I am in service, therefore.
But if they were in service, but their regular, means their minimum pay scale could not be held as government has conducted an inquiry. The government is Water Resource Department also, and the inquiry report we have placed before your lot by way of filing an additional affidavit, where we have stated that they were not engaged after 1490.
They were not engaged. When were they engaged? They are your employees.
Means
aren't you paying them salaries?
They were.
Aren't you paying them salaries? Difficult. Anything, Mr. Borpujari, from your part? Factual aspect, perhaps there is nothing for you.
In the factual situation of if my lord may be pleased to come to my lord page 23 onward of the deed petition. Page 23.
Yes.
Post Upenda's, my lord, the decision was taken by the government at the finance department,
Correct.
whereby my lord proposals were invited from respective department. Here is the my lord, the statement, my lord, of the water resource department. It starts from page 23. So people find the name of the petitioners. My lord, if my lord may be pleased to come to page 27 for a moment.
Yes.
Page number 27, serial number 28.
How many of you are there, Mr.
Yeah.
Total is 9. 3 of them had filed a retreat. Other 6 are there. 49.
Your petitioner,
Indeed.
Rajani Chaudhary,
Rajani Chaudhary is my lord petitioner number 1.
P1.
P1. Then at the same page,
Nukul Das is 2.
Nukul is P2. Nukul is P2. Then lordship will kindly turn the next page 28. 37. Serial number 37.
Pulak.
Pulak Burman is P3.
Okay.
Now, my lord, on the strength of the data that was furnished by the Water Resource Department, the Finance Department had approved. This is one aspect of the matter. Now, my lord, the department had made an internal inquiry. That is, of course, employer within own domain.
Okay.
Now they have, my lord, come to a finding that they were not engaged. This is how where, my lord,
They have come to a finding that they were not engaged. What? Complete the sentence.
they were not engaged.
Are they in service? They have not said that they are not in service.
Yeah.
They have not said that they are not working for 10 years. They have said that they are working after 1/4/1993.
After 1/4/1999. They
That
were not.
will it be a relevant aspect?
Yeah. They were not engaged post 1/4/1993. Of course, they are the employer, my lord.
No, will it be a relevant aspect for minimum wages?
Minimum wages, my lord, that 10 year we have to turn the clock back. It will start from 1/8/2007. because my lord.
From
paragraph
93, 94 to 2007, long gap.
Long gap.
Not 1 day, 2 day, something marginal.
Now, my lord, since they have
Let
taken
us not waste time.
the- Yes.
Some benefits should be given. Heard 3R Mazumdar, Learned Counsel for the petitioners. Full stop. Also heard 3 RM Das, Learned Standing Counsel. Water Resource Department. Comma. 3 R Borpujari. Party? No.
Yes, my lord.
R Borpujari, Learned Standing Counsel, Finance Department. Sharma, you are also there, no? Para, the petitioners, who are 3 in numbers, have joined together with a claim for the minimum pay scale in terms of a judgment and order dated 8/6/2017 passed by this court in WA 45 of 2017, within bracket, State of Assam and others versus Upen Das and others. Full stop. Para. The petitioners have projected that they are working as masteral workers in the department from
We assert it is 93, they assert it is 95. Page 27, madam.
From the years 1993, 1995 and 1994.
We assert that it is 93 all the time. They say it is 93, 94.
1993, full stop. 1993, full stop. Para. No, para na. It is also contended that the stipulation made by the Honorable Division Bench in the case of Upenda Supra is payment of minimum pay scale for employees who are in service, for existing employees who are in service for the last 10 years from the date of the judgment. Full stop. The Learned Counsel has also referred to the affidavit in opposition filed by the department, wherein it has been admitted that, where is that page?
Page 35, madam.
Admitted that the petitioners are working from 1993, 1994, or 1995 and 1994 respectively. Full stop. The only reason which is discernible from the affidavit is an inquiry on the aspect of their induction in the service. Full stop. Para. Sri Mazumdar, the Learned Counsel, contends that there being no dispute with the fact that the petitioners are in service for at least a period of 10 years prior to the judgment rendered in the case of Upen Das, which was on 8/6/2017, the petitioner's claim is justified and therefore necessary, and therefore appropriate directions are to be issued in this regard. Full stop. Para. Sri RM Das, Learned Standing Counsel of the department, has submitted that there is a dispute with regard to the
induction is in regard to the dates of induction of the petitioner in service, full stop. He submits that though the petitioners have contended that they were appointed prior to 1994, 1993, comma, the actual dates of their appointments are 1/6/1993, comma, 1/3/1995, and 1/3/1994 respectively, full stop. By drawing the attention of this court to the affidavit in opposition filed by the respondent number 4 on 17/2/2023, comma, more specifically, paragraph 8 thereof, comma, the learned standing council has submitted that an inquiry was held wherein inquiry was held on the aspect of the initial date of their induction, which was claimed by the petitioners to be prior to 1/4/1993, full stop. Para 3, R. Borpujari, learned standing council, finance department, while endorsing the submissions and views of the department, has also submitted that unless the date from which the petitioners are in service can be ascertained, comma, there may not be automatic application of the mandate laid down in the case of Upen Das, full stop. Para. Sri Mazumdar, the learned counsel for the petitioners, in his rejoinder has submitted that apart from the admitted fact which would be revealed in the affidavit in opposition filed by the department, that all the petitioners fulfill the criterion of length of service laid down in Upen Das Supra, comma, the salaries of the petitioners are also paid in their bank account, which would prima facie establish their claim, full stop. Para. After consideration of the rival submissions and the materials on record, comma, this court has noticed that in the affidavit in opposition filed by the department on 17/2/2023, comma, there is a clear admission, there is a clear statement with regard to the dates of initial engagement of the petitioners, full stop. For ready reference, comma, the relevant paragraph is extracted herein below, page 35, paragraph 6, full stop. The only objection for denying the benefit of payment of minimum scale of pay is on the ground that an inquiry was conducted on the claim of the petitioner that they were working prior to 1/4/1993, full stop. In the opinion of this court, comma, the aforesaid ground would not be a relevant factor at all for denying the benefit as given in the case of Upen Das Supra, full stop. In fact, comma, this court has noticed that such benefit was directed on a concession made by the state, which would be apparent from the observations made in paragraph 22 of the judgment, which is extracted here and below, full stop. The issue as to whether the claim of the petitioner to have been appointed prior to 1/4/1993 would have any relevance. No, keep going. The issue. And the issue with regard to the claim of the petitioner to have been appointed prior to 1/4/1993, on which an inquiry is stated to be done, will have no relevance at all in the present claims made by the petitioner. Full stop. There is no manner of doubt that the petitioners are in continuous service for a period of more than 10 years from the date of the judgment in Upendas Supra, which is 8/6/2017. Full stop. In view of the aforesaid facts and circumstances and the discussions made, comma, the writ petition is allowed by directing the respondent authorities to give the benefit of minimum scale of pay to the petitioners for their services rendered as master role worker at par with other candidates in terms of the judgment and order dated 8/6/2017 passed in the case of Upendas Supra.
Well, the finance department has already played their role. Complete. We have already approved. Now it is for my lord water issue.
We can record this.
Yes, my lord.
Borpudari Kopa. Sri Borpudari, however, has clarified that so far as the finance department is concerned, comma, the rule has been completed and it is up to the administrative department to take necessary steps.
I'm obliged.
But regarding the additional evidence, the inquiry report we have already funded.
But that will not be an irrelevant. I will talk about Sri Das has also placed on record, has also referred to the additional affidavit filed by the department on the aspect of enquiry. Obliged.
I'm so obliged.
29. Yes, Mr. Biswas?
Yes, ma'am.
What is this?
But I come from, we have not made party to the so-called second wife. Who has,
We are not on that. We are on the issue of suppression.
the case is pending. My lord, it has been filed by them. Of course, not, we are the respondent there. Succession was filed by us and we have been declared successor of the.
That case has been contested by you.
Yes, we have appeared. But we have not reflected in this.
You have not disclosed anything. It's on the same subject.
No,
You have tried to invoke the writ jurisdiction.
That is relates to the inheritance, my lord, of the legal successor.
Succession.
Here, my lord, government has paid us some money, retirement benefit paid, but pension has been stopped.
We have seen the interim order, want it to be kept intact.
Yes. But in, only part of the payment has been paid.
You have to pay cost, Mr. Biswas.
Well,
We don't tolerate this kind of things in a writ court. It's a court of equity. Same counsel. What do you gain by this? Are you gaining something? Temporary gain. You are suffering a huge loss.
Let me withdraw to the liberty to file.
Of course not. We are not going to allow you to withdraw. You go parallelly, you invoke writ jurisdiction in a case which is in the High Court. You are contesting that case, pending case, you don't even disclose. What is this kind of assistance?
It was a mistake.
It's not a mistake. Lawyer is the same, unfortunately.
Yes, both I was there in that case.
We have to face the consequence.
We don't sit here for this kind of things. People come with genuine grievance. What do you have to say on the part of cost to be imposed on you?
If your lordship wants to,
Who will impose cost?
I leave it to your lordship.
Who will impose cost? If you want to say anything, you can. That is why we wanted your personal presence. We could have passed orders in your presence of your learned
But
colleague.
actually, I was engaged in this matter, my lord. It is Hasibur Rahman is the case.
We don't know.
He is the person who was.
You can shift the blame to somebody else. You are aware. You have annexed that. You moved it.
Yes, I have moved it.
You have annexed that. You moved the other application. You contested the other case.
Yes, I have.
It is
appeared
brought on
that-
record by Mr. Upadhyay. Dekha. This is another glaring example of gross abuse of the process of the court by means of these petitions stated to have been filed under Article 226 of the Constitution of India. Full stop. At the outset, this court reminds itself that the powers under 226 of the Constitution of India is a power of equity, wherein the conduct of the parties are of paramount importance. Full stop. In this case, comma, it is not only the conduct of the party, but also the conduct of the counsel for the petitioner, which are in serious doubt of their bona fide. Full stop. Para. Bereft of details, comma, the facts projected in this writ petition is that the husband of the petitioner was a Khalasi, grade 4, within grade 4 employee in the establishment of the irrigation department posted at Mankachar. Full stop. The husband had passed away on 17/7/2011, leaving behind the petitioner and 9 children. Full stop. The petitioner claims to have applied for family pension on the strength of being the legally married wife of the deceased government employee, namely late Abdul Baten SK. Full stop. She also claims to be the nominee in the service book. Full stop. However, as no action was taken on her claim, comma, the present writ petition was filed in the year 2021. Full stop. Para, this court had issued notice on 3/1/2022, and pursuant to such notice, comma, the respondent number 3 has filed an affidavit in opposition on 19/5/2022. Full stop. The disclosures made in the said affidavit in opposition and the annexures would make a shocking revelation. Full stop. Para. A perusal of the said affidavit in opposition more specifically, the averments made in paragraph 4 would disclose that the petitioner had filed a succession case before the learned district judge Dhubri in Miss within bracket S oblique C bracket close case number 52/2012, which was disposed of by judgment dated 13/12/2016, full stop. The said judgment was, however, challenged by another wife of the deceased, by one Noor Jahan Khatun, who has stated herself to be another wife of the deceased government servant, by filing an appeal in this court, which was registered as FAO 10/2017, full stop. Along with the said appeal, IA within bracket civil 2966 of 2017 was filed, full stop. Pursuant to an order dated 13/8/2018, passed in the IA, an amount of rupees 4,45,649 has already been paid to the petitioner, full stop. A perusal of the orders, perusal of the copies of the order dated 13/2/2016. No, of the order dated 18, what is the date? Order dated 13/8/2018 by this court would show that the present petitioner, who was the applicant therein, is represented by the same counsel, full stop. The FAO also appears to be pending as on date, full stop. Para. The facts observed above and which has been brought to light by way of an affidavit were not only very much within the knowledge of the petitioner, what is surprising is that the facts were very much within the knowledge of the learned counsel also, who was the same in the pending FAO and the IA, and the order was passed in the year 2018, whereas the present writ petition has been filed in the year 2021. Full stop. Para. Apart from the fact that no parallel proceedings can be instituted on the same subject matter, what is more important is the act of suppression of material facts. Full stop. Para. When this matter was heard in the first half, in the absence of the leading counsel, the matter was adjourned, was deferred to the second half. Full stop. This court has indicated the aspect of imposition of cost both on the petitioner and the concerned counsel. Full stop. However, no effective response has been given denying the fact of having knowledge of the earlier proceedings. Full stop. In any case, no explanation is plausible in view of the fact that the same counsel had appeared for the petitioner in the pending FAO and IA 2966/2017 connected thereto. Full stop para. The writ petition is accordingly dismissed. Full stop. For the reason of abusing the process of this court and for want of bona fide, this court imposes cost of rupees 25,000 upon the petitioner and an equal amount on the council, on the learned council, full stop. Cost to be paid in the name of the Guwahati High Court welfare service. Yes.
Our time
And Upadhyay.
120.
C. Boro.
Alright.
Item 30.
Sorry, Milord, matter skipped in the list. My name is not indicated in the call. Anyhow, Milord,
File affidavit.
Milord, that affidavit, Milord, earlier the position was that some of the records of this case, this is the pre-amalgamation matter, Milord, connected with the UBI, which said to be in Kolkata. Now everything is centralized. I pray for a last and final opportunity of Milord, the
21 matter, Mr. Ganguly.
I understand.
Sri A. Ganguly, learned counsel for the PNB, prays for and is granted a final opportunity of 3 weeks to file affidavit in opposition.
Can a date be fixed?
List.
16th of June, Milord. No, this is 14th of June.
List on 1, 2, 3. 14th of June will be too far. Okay, we'll give you 10th of June. 10th of June.
33 and 34. May I present? Worship, petitioners is the SBL employee, my lord, working under my lord Algapur ICPS project, my lord. Since my lord 2011, his
Yes, sir.
salary has been
Mr.
stopped,
Barua?
my lord.
State Council, you file affidavit.
We have filed affidavit lordship, what happened lordship, after the coming of the judgment, read appeal lordship, Upen Das and Assam. If I mentioned in the affidavit, a consolidated list of 45 numbers of casual and similarly placed employees were prepared for available records and submitted to the Government of Social Welfare Department dated 9/12/21 for allowing scale pay as per Finance Department OM issued by so-and-so dated 3/10/20. 3/10/19, the name of the petitioner is reflected as serial number 9 in the said proposal. However, the Finance Department has rejected the proposal and the salary could not be provided to the petitioner as submitted for. So the rejection is ultimately paid by the Finance Department. Okay? So
Yes, Mr. Borpati, what grounds of rejection?
Well, so far as item number 34 is concerned, my lord, we have received the instruction of the kindly peruse it, my lord.
No, one affidavit has been filed. R3. Who's R3?
R3, my lord.
In 7305.
705.
Who's R3?
7305, my lord, R3. I do not have that petition, my lord. I am having, my lord, the next.
R3 is the Director of Social Welfare. You have filed affidavit.
If my lord may be pleased to take up item number 34, my lord, that next case, my lord, 7288. 7288. Similar matter, my lord. We have received a consolidated instruction with regard to both the matters.
What do you say?
But in fact, my lord, this is a inter-department communication, my lord. We have communicated after filing of the writ petition, we have communicated to the finance department, seeking their instructions, my lord, for the.
You have
purpose of-
communicated to finance department means?
No,
You
my
are
lord,
for whom?
the finance department.
You have communicated means?
My lord,
The council has
Council
communicated.
has communicated seeking instruction, my lord, to file affidavit. Now this has come, my lord. This is the inter-department communication.
Okay, I've got it
statistic.
then. What are the enclosures?
My lord, enclosures are not, my lord, enclosed here, wait, but my lord, the social welfare department.
No,
has-
here.
Yeah.
You have said that along with enclosures and request to kindly take step, action and submit action taken report in this department at the earliest. This is no instructions at all. What is this communication? Nothing.
No, my lord, the expectation report has been sought for, my lord, by the finance department from the, my lord, social welfare department.
Yes, social welfare.
That is awaited, my lord. But unless this comes, my lord, I am not in a position to file an affidavit. That is my humble submission.
But they have already stated their stand in the affidavit.
Then, my lord, I will have to communicate, my lord, again to the finance department on the strength of the affidavit that has been filed. My lord,
Take the affidavit,
yes,
have
my
the
lord, will kindly
affidavit.
accommodate
Okay.
me for some time, my lord.
Okay. Though the social welfare department within bracket presently, the welfare of women and child development department bracket close has filed affidavit in opposition on 18/1/2023. In this case, comma, the finance department is yet to file the affidavit or disclose its stand in the case. Full stop para. Sri R. Borpujari, the learned standing counsel finance department accordingly prays for and is granted 3 weeks time to obtain affidavit, to obtain instructions / file affidavit in opposition. Full stop para. Sri C.K.S. Barua, learned state council representing the department, representing the WWCD department, would furnish a copy of the affidavit in opposition to Sri Borpujari to enable him to seek necessary response to the stand of the department.
Most of them.
Maybe. Regarding my family pension, my lord, petitioner is the first type, my lord. And there was a agreement, my lord, between petitioner and my lord respondent, and that was submitted to the authority. And now the presently matter is pending before the government, my lord.
Yes, affidavit filed.
My lord,
Here for whom?
I respondent number 7, my lord. Second wife,
Private respondent.
my lord. And my lord, thereafter, my lord, I made a communication to the respondent as about to sign this affidavit. But till that, he has not come.
We can grant you a week, 2 weeks time to file the affidavit. That's a different matter.
My lord.
But if you are not in touch with the clients, we will not proceed indefinitely. And Madam Bora?
One for the second.
Okay, in this meantime, both of you file the affidavit. Full stop. On the request made by Ms. B. Bora, learned standing counsel, agriculture department, as well as by Sri K. R. Padgiri, learned counsel for the response number 7, comma, 3 weeks time is granted to file affidavit in opposition. You also like to file, your role is not there. Okay.
Date may be fixed.
Huh?
Date may be fixed, my lord.
Sri C. Barua, learned standing counsel, standing counsel, accountant general is present. Full stop. List on 5th of June. Enough time you get. File it before that.
Published. Published.
Item 26.
In this case, we have some difficulty on today, moreover, customer also not filed their activity.
This is item
36.
You have not filed affidavit.
But the simple grievance of the petitioner is that he has superannuated as a casual worker. Now, in spite of the judgment in Upendas, wherein it was stated, my lord, they will not be regularized and no pensionary benefits will be given. He is seeking pensionary benefits this way, my lord.
Yes, my lord.
Your
let them
case is
file an-
covered by Upendas.
Upendas. Casual worker, my lord.
My lord, let them file an affidavit. But
Why? You have to make out a case
Dismissed.
that your case has to be treated differently than those cases which were the subject matter in the lead case of Upendas.
my lord, sometime, I come after a week, my lord. Continue. I would it.
My lord, may peruse his appointment order at page 13.
1-3.
13A.
Yes.
He was engaged as casual office staff on daily wages, appointed on 10/7/1992. And my lord, he has superannuated and he finally, my lord, superannuated on 31st of December 2022.
But his appointment was prior to 1493.
Yes. He cannot be anyways regularized. Upendra says 10 or more years as on date Upendra's judgment was passed. So he's covered by Upendra's judgment. He is now his subsequent prayer now is that he should get retiral benefits post retirement. That's his limited pay.
No, what was the status of the incumbents in the case of Upandas? They
They're
were
like minimum of pay scale.
no. That was the concession of the by the state. What were their contention? They were appointed when? Before 1493 or after 1493?
My lord, they
Here
were-
you have shown from your what have you just shown, the documented Annexure 1 shows that he was appointed in July 1992.
Yes.
My lord, in Upendra's the contention that was raised by the Upendra's and by others that they are prior to 1493 and they should be regularized the cabinet. But by that time, my lord, Mahadevi's judgment was had come.
Let
by
us
then.
see at Upendas Matapahil.
Already have it. No, it's stop. I put. Confirm.
Yes.
My lord, kindly peruse the order dated 10/4/2023.
10-4.
10/4, my lord. And the last paragraph,
Yes.
kindly peruse last order, last paragraph, my lord. Access to ensure learned counsel appearing on behalf of petitioner, however, submit that the judgment rendered in the case of Upendas was a case pertaining to regularization, which the division bench of this court negated the same. However, directed that those employees who have been working for more than 10 years prior to 1/6/2017 would be entitled to the minimum scale of pay. The learned counsel for the petitioner further submitted that the office memorandum dated so was neither an issue before this division bench, nor there was any adjudication as regard the entitlement of pension. And as such, he submitted to the judgment rendered. This was not answered by the member.
When your regularization has not been granted, where is the question of pension?
As for office memorandum, page number 8.
Have you seen the order, Mr. Borpujari? Order, no, order dated 10/4/2023. He is trying to rely upon some observation in this proceeding. Have you got? Order passed in 1739/2023.
That order,
In this proceeding.
yes.
Have you got it?
No, my lord.
Have a look. 10/4. Here. 10/4.
Yes, sir.
10/4.
Yes, my lord.
Towards the last part. Yes. Please read aloud.
Mr. I.S. Sekhar, the learned counsel, appearing on behalf of the petitioner, however, submits that the judgment rendered in the case of Upendas was a case pertaining to regularization, which the division bench of this court negated the same. However, directed that those employees who have been working for more than 10 years prior to 1/6/2017 would be entitled to the minimum scale of pay. The learned counsel of the petitioner further submitted that the office memorandum dated 6/9/2003 was neither an issue before the division bench, nor there was any adjudication as regards the entitlement of the pension. And as such, he submitted that the judgment rendered in case of Upendas, so far as the observations of the state employees would not be entitled to consequential benefits, including pension, would not be a binding precedent in view of rule of sub silento. The respondents are directed to file their affidavits and so. We have, after passing of this order, we have communicated to the department, and the instructions we are awaiting, my lord, to that extent. Otherwise, my lord, when the rule of sub silento, how far?
No, when the issue of regularization has been negated by a
Negated.
division bench,
Yeah.
and this payment of minimum wage is on a concession by the state.
Yeah.
Can we again go back to the aspect of no, it has not been decided pension?
No.
Pension has to follow an order of regularization which has been negated.
Negated. And in Upenda's lordship, in the preceding paragraph, my lord, prior to 22.
Mr. Saikia?
My lord, there, my lord, the honorable division bench has heavily relied
We are
upon
just
my lord.
trying to understand the observation made by this court, last paragraph, that the aspect of pension not being discussed in Upenda, so the doctrine of sub silentio will not be a binding precedent.
First of all, but the
After Upendas, can the
case of
aspect of
Upendas-
pension be again reopened by a single
the
judge?
case of Upendas was never for a payment of pension. It was
No,
for
because-
regulation of service.
So pension is what? When will pension come?
If the lordship goes to rule 31 of.
Okay,
Second
will
rule.
pension come without your services being held to be regular? At least for the sake of pension. In the
there can
case
be-
of the Roy, what was the Roy? What was
Sanjita Roy.
Sanjita Roy.
Lordship has
We
held-
have held
That
every.
is a different case, my lord.
No,
were
how
regularized.
how you deduct 20 years?
Those
How
persons-
do you these are for the purpose of pension.
Yes, sir.
But here when the entire aspect of regularization of your service, will you still get pension? Or can
My
the
lord,
aspect of pension be even discussed?
my lord, as per Rule 31, a person should be paid monthly wise and they should get the salary from the government. If there is no post, if they are not confirmed also, the governor can make a declaration that their services are concerned. And that declaration is made, my lord, in, my lord, the page 19. Page the 19.
19.
Wherein, my lord, it has been said that the 20 years continuous service is sufficient for payment of pay. If have understood correctly.
It is therefore clarified that pensionary benefits are contemplated in the above OM shall be admissible to a government servant who died after rendering 20 years of. Here in the case, who has come? Person who, the legal heirs.
No. Petitioner himself, my lord, himself. Is the clarification of the page 18, my lord. Isn't it?
Yes, you file your affidavit.
My lord. Because affidavit will be required. There is a contract.
That apart, my lord, the payment of gratuity, they have paid to some, my lord, person working in the other department, my lord. The petitioner before lawsuit has not been paid. Gratuity amount.
Gratuity aspect, I think it is
Gratuity-
governed by the Gratuity Act,
Yes.
payment of Gratuity
Yes,
Act.
ma'am.
There is no bar, should not be any bar
Yes,
unless
yes, yes.
there is a DP of destruction of property causing
Absolutely,
loss.
Absolutely.
That may be
Gratuity
Law-
is not under
Section
those
4,
circumstances,
Section
my
4.
lord. Yes, the employer cannot hold gratuity, hold up.
That can be directed to
That
the
is a
page, ma'am.
statutory liability. But here, my lord, he is relying on a, my lord, office.
Okay, you
going
file
right.
affidavit,
Right.
okay? On the prayer of Sri R. Pujari, Learned Standing Council Finance, as well as Sri P. Hendik, Learned Standing Council, PNRD Department, 3 weeks' time is granted to file affidavit in opposition.
Obliged, my lord.
Item 57.
Matter pattern, non-release of family pension, my lord. Here, my lord, from the affidavit filed by the Union of India, my lord, they have said that the petitioner, they have already, my lord, sanctioned the family pension, my lord. The petitioner.
Yes, madam.
Lordship, we ourselves have stated that she is entitled for page 21 of my affidavit, Lordship.
Now why not paid then?
Now, my lord, the one communication, my lord, that is not visible, my lord, even my lord can read, my lord. Here we received by the, my lord, Central Pension Processing Center, my lord. It has stated that, my lord, the regular pension was discontinued since long, that is more than 4 years. My lord, attract fresh sanction by the pension sanctioning authority.
Lordship, that is of 2024. In 2021, Lordship, page 30, we have stated to the Treasury officer, also given copy of our letter that there is no need of separate PPO because her name jointly was with her husband. And as per this, the same PPO will do, and she is entitled for all the pension. Page 30. This is the letter.
SBI is a party here.
Yes, my lord.
SBI is a part.
My lord, in fact, my lord, in causes, their names are also shown, my
Who's there?
lord. My lord,
Name. S. Dutta.
my lord, and
S. Dutta, I think this is,
as Dr. Miss P. Sharma, as per case, just student number 6.
Yes, doctor, yes. I don't know, let me think. The quite best PPO is, well, it is only 4 years, well, in fact, well, it
What
is
is his full name, Mr. S. Dutta? Appears for SBI.
it is 50 there, well, there,
I don't know. Subroto. Subroto. You contact him, because there are two, 3 as doctor, so he must have missed it, and he's not very regular in the High Court. Ask him to come, we'll sort out your matter. SBI cannot take this stand, and Madam has clearly said that there is no requirement of another. So we'll give a direction, and passing a direction in his presence will help you. We'll expedite the matter. Otherwise, we can dispose this off. Try to have him day after tomorrow.
Right.
Okay?
Can it be on Monday, Lord? Friday, little.
Monday? Okay, no problem. Oh. Doe 3 S. Hawk, Learned Counsel for the petitioner, and Miss B. Sharma, Learned CDC, are present, 3 S. Datta, Learned C. Subrata Datta, Learned Counsel, appearing for the SBI, is absent, full stop para. The pleadings exchanged would require the exchange would need the response of the SBI for an effective adjudication. Full stop para. In the interest of justice, matter is adjourned to be listed on 13/5. Please inform him. Yes, Mr. Gogoi, what is this?
Yeah, please, Sudhir. Lordship, this is matter regarding a non-payment of compassionate family pension. Lordship.
Okay.
Lordship.
Well, here, the last order of the Honorable Court, 18/7/23. The Lordship has directed us to clarify the person concerned, the husband of the petitioner, he was an employee of the Assam Human Rights. And Lordship has directed us to clarify as to whether the employee of Assam Human Rights Commission is a government employee and whether he is
Come within the scheme.
I have received the instruction from the political pay department that the Human Rights Commission is a autonomous body and as such he is not under the.
So he'll not come into the scheme.
Not covered by.
File
the
an affidavit.
Yes, my lord, and it
Please,
is up to the authority, the autonomous body concerned with what.
Anybody appearing for human rights?
But Human Rights Commission, I have received a letter from them, my lord. Lordship, I'll just bring the instruction letter from the political lady.
Lordship,
Mr. Gogoi, is human rights a party?
Yes,
Lordship,
yes,
Human Rights is a party and
Anyone appeared?
They have in
PC
fact given,
Sophia probably
they have
accept the
in fact
notice.
given-
Lordship.
they have in fact given us a
On
letter.
Human Rights.
Okay.
Lordship, on
Mr.
the
Nath,
file-
you filed the affidavit.
I'll file.
Uh, Yes, you're for AG.
As you take care, my submission is dictated. The someone is like commission is an autonomous body to be an person. But I don't have any rules. Because they think that they may be required another public works and public works. I don't know whether it is there.
No, they have already
Because
taken.
they have made
They
a
have already
party,
taken the view.
they'll be in fact, it will be doing, but it will not be. Ultimately, that is not. They are not.
It is the Human Rights Commission, they have to give the benefit from their own.
That is. that is-
Sri D.
I'll
Nath,
file it.
learned senior advocate
1, 2, and 4.
for the official respondents has submitted on instructions that the scheme of payment of scheme of payment of compassionate pension.
Family
pension.
Compassionate family pension is not applicable to the employees of the Human Rights Commission, which is an autonomous body. And any such decision is within the domain of the commission. Any such decision to be taken is within the domain of the commission. Full stop. Para. Sri C. Barua, Learned Standing Council,
Okay.
Accountant General, has submitted that his client does not have any role in the subject matter of payment of compassionate family pension. Full stop. Para. Let an affidavit be filed by the official respondent on the aspect of the applicability of the scheme vis-a-vis the employees of the Human Rights Commission. List after 3 weeks?
No.
3 weeks. Along with the affidavit that may be filed. That has been directed to be filed.
41.
Please, Lordship.
Yes.
Lordship, this case is basically for regularization of gap period of services, Lordship, for releasing unpaid salaries, for releasing Lordship area of compassionate family pension, Lordship. In this case, Lordship, notice was issued with a direction to the Education Department, Lordship.
Yes.
That is on 31st May 2023.
Yes, seen notice was issued. Yes, any instructions?
No, ma'am.
Yeah, for which department?
Elementary education.
You get the instruction, it is
Yes,
a-
sir.
almost a year has passed.
Yes,
That is in May.
matter has been listed the first time for after. the
That is not an answer.
Yes, ma'am.
1 year has passed, you have to have the affidavit filed by now.
Yes.
Mr. Bhattacharya for AG. Your role will be there. Okay.
With regard to that instruction was called for.
Your name?
Deepak.
Oh, yes. Sri G. Pegu, Learned Standing Council.
Yes.
Standing Council for
Depending on the elementary.
Elementary Education Department submits that complete instructions are awaited.
Yes.
For which he prays for time. Full stop. Para. Considering that this matter has been listed for the first time after notice was issued, 4 weeks time is granted for filing affidavit in opposition. Full stop. For taking necessary instructions, less filing affidavit in opposition. Full stop. Para. Since Sri D. Bhattacharya, Learned Standing Council, Accountant General Assam, has submitted that the pension papers were returned for correction of some anomalies, for rectification of some anomalies, instructions in this regard are also directed to be taken by Sri Pegu.
Bless.
42.
Lordship.
42.
Lordship, the counsel for the petitioner is.
Okay. Health, you're for health. I think you had made a mention.
Yes, Lordship.
Somebody is not, who is not well? What has happened? He's out of station.
Yes, sir.
Who?
MJ Barua.
He's not in Guwahati.
Not in Guwahati.
Okay.
He's in Dhubri, sir.
Okay. The learned, it is submitted that the learned counsel for the petitioner is out of station and therefore a prayer for adjournment has been made. Full stop. Para. List after 2 weeks. You have filed affidavit. List of it also transpires that affidavit in opposition is yet to be filed. Full stop. Para. List of the 3 weeks to enable filing of affidavit in opposition. Okay. Next.
44.
44.
Which I may be allowed to file our affidavit, Lordship.
Who is for the, none appears for the petitioner on call. Even on the last occasion, that is 24/11/2023, none had appeared for the petitioner. Full stop. Para, Miss M.M. Kotoki, Learned Standing Council. Animal Husbandry and Veterinary Department is however present. Full stop. Para, in the interest of justice, let another opportunity be granted to the petitioner to make representation. Full stop. Para, list on Monday, huh? List on 23 minutes. List on Monday next. Full stop. It is made clear that in case of further non-representation, this court may pass appropriate orders.
Okay.
45.
May please the lordship. My lord, here in this case, my lord, the petitioner has filed this writ petition for payment of 50% of the my lord, admitted amount, my lord. The petitioner is the principal of
Admitted amount of what?
admitted principal of the, my lord, your lordship, ITC My Fair Lady Training Center, my lord. So your lordship may kindly peruse Annexure A at page 12, my lord.
50% of
She has
what?
been entrusted with the charge of giving training to some students, my lord, and 50% have already been paid to her.
This
And
entrustment was given by whom?
by, my lord, the Director Employment and Craftsman Training Assam, page 12, my lord.
You have received half of your,
Yes, my lord.
half is still
But
pending.
training has already been completed.
Yes, madam,
and the
for whom?
petitioner.
Respondent number 3,
Who's free?
that's Mr. On behalf, I am appearing on behalf of Mr. S. Vikas, Director, and
What, you have any instructions?
we have
Let
not
me-
received the copy of the writ petition.
My lord, here, my lord, we have already taken steps on respondent number 2, the director, my lord, who is supposed to make the payment, my lord, by registered AD as well as Dusty Service, my lord.
For 1 and 2, I have appeared. 1 and 5.
And you are for?
Respondent number 3.
3 is,
3 is the director. and
Director.
you have been served, madam.
We have, my lord, taken steps by Dusty and we have also filed affidavit, my lord. And so my humble prayer is that, my lord, your lordship may
Dusty,
dispose
when
of
did
the
you,
matter with the direction to make the.
when did you
50%.
serve Dusty, madam?
My lord, Dusty service has been made on 9/2/2024. And we have filed affidavit on 29/2/2024.
Where is the order by which you are,
Page 12, my lord.
no, by which you were permitted to serve Dusty?
Oh, my lord, order. As per order dated, my lord. 9/2/2024.
9/2/2024.
ma'am.
Okay. Upon respond number 2. You are for 2.
No, respondent number 3.
2.
2, I.
The managing director.
Yes, managing director. Managing director, State, Assam State Development Corporation for Schedule.
So you are there,
Yes, I'm
and madam, you are for 3.
for 3.
So 2 is already, 2 has already appeared. The direction was upon respond number 2.
Yes, my lord.
What is your take on this?
Well, I have received the instructions. My instruction says that submission of required report is not available. The petitioner has to provide training to 200 SC cadets.
Okay.
And 50% has been already at the starting of the training, but as per guidelines, that has been given.
Okay.
After completion of training, the report has to be submitted to the authority so that the rest portion of the amount can be paid. That report is not available in that.
And
So after that, unless the report is submitted, they have some, they have.
Who will submit the report?
The, as per the guidelines, the petitioner has to submit for that the training has been.
My lord, annexure C, my lord,
Page
14, my lord.
14.
Yes, my lord. He has also submitted the list of 30 students, my lord. And representation is also there, my lord, annexure D1, D2.
The candidates were selected by the respondent number 3. And ultimately, respondent number 3, the petitioner has worked under them. It is the respondent number 2 will pay the amount. Training will be conducted by the petitioner and petitioner has been engaged by 3. They are the agent of respondent number. And ultimately, for the release of the amount, the report of completion of the training has to come to the respondent number. That is not the.
No, no, where did it come from? From the petitioners or from the respondent number 2?
For
All are before us. Will pass necessary direction, complete the formalities. Why should amount, if they are entitled to be held up? If they are not
Amount-
entitled,
Yes,
it
my
doesn't
lord,
matter.
1,80,000, my lord.
Yes, sir.
And you have not disputed the completion of the training, number one.
No, that is not with us.
If somebody has done something,
The report is not with us. We have to ultimately.
you tell us who will give the report. If the petitioner needs to refurnish the report, they will give. If respondent number 2 has to give, who will give?
Let them submit it. My instruction is
We
that
have
only.
annexure C.
No, it is annexure C. Annexure C is for. But this
With
is the,
reference to, I have the honor to inform you that as per order letter dated 28 July to 30 numbers of SC students on the trade of so and so are doing their classes regular. We are enclosing their list of the students.
Madam,
who
where
have
is your
joined.
statement?
Then subsequently, they have
Madam,
completed.
where is the statement in the writ petition regarding completion of the
Yes, my lord.
training?
this is not the completion report. Then it is C.
Para 4, the petitioner after completion of the aforesaid course successfully, para 4, the petitioner approves the respondent upon requested to make the payment of remaining 50% in terms of order so and so. The petitioner also made representation dated. There are 3 numbers of representations we have I have annexed my annexure D1, D2, and D3.
So in the guideline, my lord, there are specific formats under which that has to be provided for. But that guideline and all these things, Lord, I'll file the affidavit.
No need of exchange of pleadings if you are in principle not taking that stand that they had not completed. Instead of making the process lengthy, you can indicate us informally that what format is to be adopted. They'll fulfill the format. Madam, are you aware of some format to furnish the report of completion?
It is when the order was given in that moment, my lord, it is there, my lord. Just family testing is done. And the respondent number 2 has executed this or implemented this for the respondent number 3. Ultimately, this testing. Just for a moment, but kindly see. This is the letter by respondent number 2 to respondent number 3. And the respondent number 3 has ultimately chosen the petition. And there are annexures in that. Completion certificate and all these things have to be given.
Let Mr. Das come, we'll pass orders directing him to, instead of exchange of affidavit.
Yes.
If the matter would have been a case of denial of the work, then matter would have been different. When would Mr. Das come with? Is he there in Guwahati? On Friday? Okay. Oh. Heard Miss S.B. Chaudhary, Senate Counsel for the petition and full stop. Also heard Sri D. Nath, the learned senior guy advocate Assam for the official respondents full stop.
So
It is-
one and two.
1 and 2.
Sorry.
The respondent number 3 is represented by learned counsel who submits that the standing counsel Sri S.P. Das could not be available today due to personal inconvenience. Full stop. What is your name? We'll record your name. As Busha. I got S. Busha. Let's submit it. Para. On request, list on Friday. Purohit. Let the name, Friday list Monday Monday. Let the name of Sri S.P. Das, standing counsel. What is the new name? Employment,
Director, Employment and Craftsman Training. Employment and Craftsman Training.
employment and craftsman training be reflected in the cause list. Okay.
Okay.
Item 47. Yes, Mr. Sharma.
Yes, my lord. Your lordship, the initial prayer in this writ petition was that the petitioner under Rule 6(2) of the rules of 1964, he was put under suspension by order which is dated 25/10/2023.
Hmm.
Thereafter, your lordship, the order was extended for a period of further 3 months.
Hmm.
Our contention, your lordship, in this writ petition is that the extension of that order of suspension could not have been carried out by the authority in the presence of the OM, which is at page 41.
Extension was, when was extension?
It was the extension, your lordship, at, on
Page, the date.
date 19/2/2024. He was put under suspension from 25/10/2023 with effect from the date of his arrest, which is 16/10. Now, the law in this matter, your lordship, is very clear. If your lordship kindly comes to page 41 for a moment, page 41.
Yes.
Yes, page 41. Page 41, your lordship. Your lordship gets the office memorandum here.
Hmm.
Yes. The second paragraph, the first paragraph is also relevant here. The Honorable High Court, Guwahati, in its order dated 30/11/2017, in a series of writ petition, the leading case being so and so, has directed to issue a notification indicating the law laid down by the Honorable Supreme Court in Ajay Kumar Chaudhary versus the Union of India case to the effect that the disciplinary authorities are to strictly comply with the requirement to issue the memorandum of charges charge sheet before the expiry of 3 months from the date of issuance of the order of suspension. It is therefore directed that all the senior most secretaries of all the departments shall ensure that the memorandum of charges / charge sheet is served on delinquent officer / employee before the expiry of 3 months or period from the date of issuance of order of suspension. They shall also ensure that the currency of the suspension order should not extend beyond 3 months. If within this period, the memorandum of charge, / charge sheet is not served on the delinquent officer / employee, if the charge sheet is served within 3 months of suspension, a reasoned order must be passed for the extension of the suspension wherever necessary. Going through this provision, your lordship,
There is some mistake in this line. The knot is missing.
Yes. Yes.
Last two lines are repeated and one knot is missing.
Yes.
Okay.
Now, your lordship would see a perusal of these two paragraphs. They would indicate that an extension of an order of suspension is based on two aspects. One is that there has to be a reasoned order which extends the suspension period. That is not in dispute. But that is a second leg that has to be used, your lordship. The first trigger for extension of an order has to be furnishing of a charge sheet. My friend here for the government had submitted categorically that the charge sheet is in the process of being served. Now, without furnishing a charge sheet,
When was it served?
he is in the process of being served. He is not been served as yet. Now, your lordship will
Now
kindly,
till now?
not till now. Now, your lordship will kindly come to page 38. Page 38, your lordship.
Yes.
This is the relevant order, your lordship. Page 38, annexure J.
38.
Yes, I apologize, your lordship, there are not better, the copy is an older copy. This is the order based on which the subsequent OM was passed.
Okay.
This is the order, your lordship.
Okay.
Now, your lordship would kindly come to page 39. Page 39.
Yes.
Your lordship, has it?
These a lot of water has flowed after this.
Yes.
Division bench has said said in Rakibuddin case. Now, what is your contention?
Now contention is, since there is no charge sheet which has been furnished to the delinquent officer, the petitioner here, the suspension, even in the presence of a reasoned order, it cannot be extended beyond the period of 3 months. That 3 month had expired, your lordship.
Charge sheet not yet submitted.
It's not yet submitted.
What is your submission?
The submission is that in the absence of a memorandum of charge or charge sheet, which is directed in categorical terms to be furnished to the employee within 3 months, which having not been done, a reasoned order cannot supplement that place and thereby extend the period of suspension of the petition.
Wholly unsustainable argument.
That could not have been done, your lordship. The
Only
language,
unsustainable. Don't make these submissions.
the OM is
This
clear.
is
Your
a superior court, Mr.
Yes,
Sharma.
yes.
We expect better submission from you.
Yes, your lordship, but
In all cases, it's possible to complete or initiate a proceeding within
it is
90 days.
no, your lordship.
Then it will go.
No, no, your lordship would kindly see this is
How will
the-
you save a situation?
no,
Tell
this-
us.
This is the order. This is the language of the OM. I understand there are categorical difficulties, your lordship.
It's not a question of categorical difficulties. It's a question of how you apply the law.
The law, your lordship, even Ajay Chaudhary in paragraph 21 and 22, your lordship, that is my,
Sorry,
that
sorry,
is
sorry,
that is the.
That is not a correct interpretation. That should not be an interpretation. You should not advise clients like this.
In fact, your
Oh,
lordship,
you are not happy.
no, in fact, we have filed.
How do you advise a client?
Yes, yes.
In spite of having a show cause notice or the time not expired, you say that no, the extension cannot be done. It
No.
has to be done within 90 days.
The 90 days period has expired, your lordship.
Understood,
Yes.
but it was extended.
It was extended thereafter,
What thereafter? You said
19-2.
19-2?
Yes, yes, yes.
19-2?
19-2.
Yes.
Yes.
11, 12, 1. When was it extended?
It was,
Have you challenged the extension order?
it has been challenging the.
Where?
Yes.
Let us see. What is your particular challenge?
Yes. Your lordship would,
This is another aspect, this we may consider, but the other aspect, no, not at all.
page 15 is the prayer portion, your lordship. Page 15.
15 years.
Yes, page 15, your lordship, prayer number 2.
Yes.
A writ in the nature of the certiorari
Setting
should
aside
not
the-
be issued, setting aside / quashing the order notification dated
Yes, let
19.
us see annexure H, page 36.
Yes,
See, so the suspension and suspension. Has been contemplated in the. At this stage. Yes, how do you overcome this 3 months, Mr. Sharma Bora?
lordship, this has been, this order has been passed based on this minutes of lordship. Lordship may kindly see the next page number 64 of the affidavit in operation. lordship.
Now we objectively examine this.
Yes, lordship.
When was the extension done?
The extension order is lordship at page dated 19 February 2024, lordship. Except for,
Was it within a period of 90 days?
No, this order for suspension was on 16/10/23. After that, Lordship, this extension of suspension for 3 months was been done from 25/1/24. So 16/10,
25/1.
25/1/24.
When was it communicated?
It was communicated
19/2.
and it was held on 2/2.
19/2. You cannot retrospectively extend an order of suspension. And it is the date of communication.
3 months was over on 16/1. So 16/1 to 25. Ultimately, Lordship, the thing is that this order has been passed based on this, there's a minutes of meeting there, Lordship. Of 2/2/24, Lordship, which I have annexed.
Minutes of meeting is not a communication. It is the decision which has to be communicated to have the form of an order. These are all settled laws.
And subject to what your lordship says.
Wait.
Yes, yes.
Lordship, the SOPOS notice was issued on 6/4/24, Lordship.
6/4. No, we are not on the show cause. We are not saying anything about expressing anything
communication
about
of
those.
the order, Lordship.
We are on the aspect of suspension. How do you extend the suspension? You have to extend, you have all the powers to extend.
There has to be reason order, Lordship. but-
No, forget about the reason. There has to be an order of extension
Lordship.
within a period before expiry of 90 days.
Lordship, I agree,
That is a
There's a gap
fundamental
period,
law. Whether you assign reasons and whether the reasons are good or bad, that's a different aspect.
I got
That
your
you have
lordship.
not assigned reasons or reasons are not good.
But
that
it has to
remain-
be a continuous
It
process.
has to be within 90 days. It has
I
not
understand,
come.
Lordship.
You say it's a serious charge and you don't pass an order of extension. How do you overcome
And
this?
Lordship, this charges, Lordship, why would you could not frame the charges within time, Lordship? Lordship,
No, Mr. C.K.S. Barua, we have already indicated to Mr. Sharma, in all cases, it may not be possible to initiate a disciplinary proceeding or to draw up a
understand,
charge.
yes.
So it is only for such situation, how to save is such a situation, is you review it.
Lordship.
That we are not being able to, what do you do? Is it required to extend the suspension? Or is it required to revoke the suspension? Charges are serious. His presence in the office may prejudice us. Extend the suspension. That's enough, one word.
Lordship,
Or the charges are based on documents.
I
He may
agree.
tamper with the documents.
This committee, meeting of review committee should have been taken place before 16th of January.
Before
Before
16th of
January.
16th of
Yes,
January.
but this has taken out 2/2/24.
And not only 16th, it is before 25/10,
Yes, yes,
2023.
then only an order could have been passed. Yes, Lordship, I got your Lordship point. There is a gap period.
And there are case laws, how a suspension order would be effective, which date, when a date of termination would be effective. You need communication is a must. Yes, what are the case laws on communication?
Your lordship, my subject matter case laws here have been on interpretation of
What that interpretation we are not accepting?
that poem, your lordship.
What is the communication?
Yes.
Orders.
Your lordship, 2009-8 SCC.
Name.
Union of India and others versus Deepak Malik. The judgment was decided on 15/12/2009.
What has been stated?
Yes. If I may read the relevant paragraph.
Yes, please.
The case sought to be made out on behalf of the petitioner, Union of India, as to the case of delay in reviewing the respondent's case is not very convincing. Section 19(4) of the Administrative Tribunals Act 1985 speaks of abatement of proceedings once an original application under State Act was admitted. In this case, what is important is that by operation of Sub-Rule 6 of Rule 10 of the 1965 rules, the order of suspension would not survive the period of 90 days unless it was extended after review. Since admittedly the review had not been conducted within 90 days from the date of suspension, it became invalid after 90 days. Since neither was there any review nor extension within the
Mr.
state.
Sharma, we are on a finer point. We are not on the broad point of not being done within 90 days. We are on the part of communication.
Lord,
What effect will a communication on not communicating, will it have any effect? Will it be in the shape of an order? Will it be recognized by law?
Lordship,
By a decision taking not communicated?
I'll scale up, Your Lordship, to assist this court, Your Lordship, kindly.
These are certain basic.
Yes, yes. Yes. My fault.
Come prepared to the court. An order of suspension of the petitioner dated 25/10/2023 is the subject matter of challenge in this writ petition. Full stop. The primary ground of challenge is that though there was an order of extension of the suspension order on 19/2/2024, it was not within the mandate of 90 days from the date of suspension. Full stop. Para, I have heard Sri M. Sharma, learned counsel for the petitioner. I have also heard Sri C.K.S. Barua, learned state counsel, appearing for the official respondents, who has also filed an affidavit in opposition on 8/4/2024. Full stop. Para. Sri Sharma, the learned counsel, has drawn the attention of this court. I have submitted that the petitioner, while discharging his duties as Assistant Commissioner, Kamrup, was placed under suspension via an order dated 25/10/2023. Full stop. The aforesaid order of suspension was passed in consequence of the arrest and detention of the petitioner in a case under the Prevention of Corruption Act on 16/10/2023. Full stop. Therefore, under Rule 6(2) of the Assam Services within bracket Discipline and Appeal bracket close rules 1964, he was placed under suspension with effect from 16/10/2023. Full stop. The learned counsel for the petitioner has submitted that he was kept under suspension continuously and no order of extension, no order of periodic review was passed within the period of 90 days, which is required under the law. Full stop. The department, the personnel department, however, has passed an order on 19/2/2024 whereby the suspension was extended for another period of 3 months with effect from 25/1/2024
2024. Full stop. The learned counsel further submits that the show cause notice is yet to be served upon the show cause notice is yet to be served upon the petitioner, and therefore the charges are not framed as yet. Full stop. Para. Sri Sharma, the learned counsel, has also tried to rely upon an office memorandum dated 4/2/2020, which has been issued pursuant to an order of this court. Full stop. It is submitted that if a show cause notice / charge sheet is not issued within the period of 3 months, even a reasoned order of extension of suspension would not entitle the department to keep a delinquent under suspension. Full stop. Para. Sri Sharma Burwa, the learned state counsel, by referring to the affidavit in opposition filed on 8/4/2024, has however submitted that the charges against the petitioner are grave, which involves the Prevention of Corruption Act, in which he was also arrested. Full stop. The learned state counsel has also submitted that though the suspension order has been extended on 19/2/2024, the same is given effect from 25/1/2024. Full stop. He has also pointed out that the initial order of suspension dated 25, though is dated 25/10/2023, the same has been given effect from 16/10/2023. Full stop. Para. The rival submissions have been duly considered, and the materials placed before this court have been carefully examined. Full stop. Para. The law regarding the procedures to be followed involving suspension of a government servant is laid down in the Assam Discipline and Appeal Service 1964, Rules of 1964. Full stop. With regard to the perimeter provision in the central services and other state services, there is an authoritative pronouncement of the Honorable Supreme Court in the case of Ajay Chaudhary versus so-and-so, reported in so-and-so. Full stop. Para. A division bench of this court in the case of Rakibuddin, State of Assam versus Rakibuddin, has clarified that even in a case of deemed suspension, the same rigors of having the order of suspension periodically reviewed and extended before expiry of 3 months has been held to be mandatory. Full stop. Para. It is also a settled law that an order of suspension takes effect on the date when the same is issued. Full stop. In the instant case, comma, the suspension order was issued on 25/10/2023, and the period of 3 months had expired on or about 24/1/2023. Full stop. Even if the effective date of suspension is held to be 16/10/2023, comma, that would make the date of expiry of 90 days to be on or around 16/1/2023. Full stop. 24. Full stop. There is no dispute that the extension order was passed only on 19/2/2024. Full stop. The But State Council has tried to explain that though the extension order is dated 19/2/2024, comma, the effect has been given with effect from, oh no, with effect has been given from 25/1/2024, when the meeting was held. Full stop. Same day meeting was held?
No, it's not tentative. It was second of February 2024. Yes,
Then how do you give effect? No. Has given effect from 25/1/2024. Full stop. Para. Apart from the settled position that a review exercise to extend or not to extend an order of suspension is mandatorily required to be done within a period of 3 months from the date of the order of suspension, comma, in the present case, comma, when admittedly the order to extend was passed on 19/2/2024, comma, the same could not have been given effect from a prior date, i.e. 25/1/2024, which is not permitted in law. Full stop. Para. This court is of the considered opinion that the authorities are not without any jurisdiction or power to extend an order of suspension in case where the charges cannot be leveled by way of a formal charge sheet / show cause notice within this period, within a period of 90 days. And therefore, and the only requirement is to have a periodic review within the said period of 90 days and pass appropriate orders within that period. Full stop. The lapse on the part of the authorities cannot be made, cannot be a ground for giving effect to an order of extension which is admittedly made beyond the period of 90 days. Full stop. Para. As regards the submission made on behalf of the petitioner that in absence of a search sheet within the period of 90 days, even a recent order of extension is not permissible. Recent order of extension of suspension is not permissible, is however not accepted, as the same is not untenable in law. Full stop. Para. Be that as it may, this court on the individual is, in view of the aforesaid discussion, they impugned order of suspension of the petitioner. The order of suspension of the petitioner dated 25/10/2023 is held to have spent its force on expiry of 3 months, as no order of review / extension was passed prior to that. Full stop. A subsequent order of extension would not cure the defect which has already been done. Full stop. Para. The order of suspension accordingly is accordingly held to have spent its force, and accordingly a direction is issued to reinstate the petitioner in service. Full stop. However, taking into account the nature of the charge and also the involvement and arrest of the petitioner in a police case, the authorities are at liberty to post the petitioner in any non-sensitive post. Full stop. The writ petition accordingly stands allowed in the manner indicated above.
In fact, Your Lordship, if I may be permitted, I'm the petitioner counsel, Your Lordship, in full agreement with Lordship's observation that there are absolutely a lot of constraints for a charge sheet to be served within 3 months. But that is not in that I can never disagree with Your Lordship. But the wordings, in fact, their clarification ought to have.
OM is not law.
In fact, the Ajay Chaudhary's case.
OM is not law.
Ajay Chaudhary's case also, Your Lordship.
You have not read the division bench. You read the division bench. Rekibuddin case.
Similar judgments also the footnote B.
Yes, Mr.
I disagree. Here the order is that a representation will be made to the department and the department will consider the representation. In my particular case, my lord, I have left that department, I have joined another department. Now my representing to my earlier department for correctification of my pay, when the law is in my favor, my lord, that should not be covered. Very.
Now you can represent before to your present.
My current department is protecting my pay as given in my earlier department. My earlier department had not protected my pay in the department where I had worked earlier to them. They have refused that pay. The Sanjeev Kapoor case, as decided by the Delhi High Court.
So you are you have worked in 3 places.
Four. The first one I joined new, that was a PSU. Second, I joined the government department. They protected my pay. Third, I joined the PRO.
they refused to protect my pay, saying that from a PSU to a government, my pay could not have been protected. Then I joined the railway. Railway is giving me what BRO has given, and they are ready to give me if the BRO gives correctly fixes my pay, railway is ready to give it to me. So it is only whether
Yeah, for the BRO.
the BRO could have stopped it or not.
Yes, what do you say?
In fact, my lord, the CAT had allowed my OA. I had won the case in the CAT, but since there was a judgment which said that for persons of BRO, the grave, CAT would not have the jurisdiction. Therefore, my lord, the order of the CAT was set aside, and therefore I am again before this honorable court with the same fact, with the same judge. Sanjeev Kapoor judgment, Delhi High Court has said that even if a person comes from a PSU to a government
Yes, what do you
organization,
say?
Lordship, there is notification, Lordship.
which allow it in my favor.
No. This is
Pay
the
protection.
2020 notification. He was not a direct, he was a direct recruit.
Notification will not overrule the High Court.
He is a direct recruitment, Lordship. He entered into the service by direct recruit.
Doesn't matter.
Lordship, that notification, Lordship.
Even High Court services,
Lordship.
we induct persons from who are stenographers in the some other.
Yes, Lordship. It come, he is, he comes to service by open interview, Lordship. UPSC law.
No, open interview, he applies through a proper channel.
Lordship.
There is a requirement when you are employed somewhere
Lordship.
and you are interested to participate in a direct recruitment process,
Lordship.
you have to apply through proper channel.
Lordship.
You cannot go and just say independently, no,
But
no, no.
Lordship, this notification. we
Why
have-
is the requirement of proper channel? Because the new employer, if you are selected,
Lordship.
has to know that where you were working earlier, is there any requirement of a pay protection? It's not a private employment. Even the initial employee in PSU, that is not a private employment. And PSU matter has become history. He has gone to a State Department,
Lordship.
then to BRO.
Lordship, kindly have this notification, Lordship,
Yes.
of 2020, Lordship, protection of pay.
Yes.
It was clarified 1989 and this two notification which we are relying on.
Hmm.
The understanding is directed to refer to department when dated so when dated so on the subject cited above where by guidelines for fixation and pay of the candidate working in a public sector undertaking, etc., including central public undertaking, state government undertaking, universities.
Please read 4, paragraph 4.
The president is pleased to decide that notwithstanding the mode of selection, henceforth the benefit of the pay protection will be available to the direct recruitment appointed in the central government to those posts for which the relevant recruitment rule prescribe a requirement of minimum number of years of experience in a specified area from the field source, autonomous body PSU, for appointment under the method of direct recruitment. The benefit will be allowed irrespective of whether the post is filled by the recruitment agency on the basis of interview or open competitive examination or both combination of both.
After this,
Lordship, they have to make in representation, Lordship, that order, Lord.
That is what this
what about paragraph 4?
Lordship.
Under 4, you have to give him whether it's a direct recruitment
Lordship.
in your induction program or
interview. Whether it is interview or open.
Lordship, in terms of that order, Lordship, let him make a representation to the department.
To whom, my lord? The department where I have already left and who has denied it to me at page 31, I have been denied the same.
where page 30?
Page 31, lordship will find is the denial order. Annexure 7. Page 31 of my read. Para number 2 may I read, my lord? The case for protection of pay of Sri Mukesh Kumar Jha, AE Civil, has been examined in consultation with the Ministry of Defence. Ministry of Defence has not agreed to grant the benefit of protection of pay to the aforesaid officer, stating that the Government of India's order number so-and-so clearly clarifies that the benefit of pay protection under the order is available only if the selection is through interview and not through open competitive examination. Wherever the protection under the above order is to be given, Commission will indicate its recommendation letter by the Ministry concerned that the pay of the such candidate should be fixed as per guidelines laid down in the DOPT Amendment 1998. The clarification is it now says that it has to be given to both open competition or interview. That has been clarified in 2020. My rejection came in 2009. So they are now giving a retrospective effect to the 2020 memorandum also. I was entitled for a clarification pay in the BRO at 9650. I have no grievance against the Indian Railways. They are ready to give me what BRO will give me.
The order of the cat, my lord, which have held me entitled, that lordship will find at page 35. This OMs had been discussed. And the case of Sanjog Kapoor at page 37. Ordering the way starts at page 35, relevant portion at 37, if lordship will have paragraph 5. High Court of Delhi order. In these circumstances, we hold that the distinction sought to be drawn between candidates selected from a non-government bodies through interview and those selected through open competitive examination is sense rational justification. Protecting the pay on one hand and not protecting the pay of the other set of candidates is completely arbitrary and illogical. The purpose behind the grant of reputation was to draw talent from organizations like PSUs. The best talent is drawn through the civil service examination, encouraging employees of PSUs to sit for examination which is rightly competitive is in line with the purpose behind the OM of 1989 of attracting the best talent. Even assuming that the purpose of pay protection, the distinction between the selection through interview and selection through open competitive examination does hold a rational nexus. The civil service examination through which the petitioner has been selected also comprises a comprehensive interview. Therefore, denial of pay protection benefit to the petitioner is unjustified and illegal. Besides, the two OMs which Mr. So-and-so is relying are rendered in the context of public sector undertakings, whereas the applicant was an employee of the state of Arunachal. Now, what I was drawing in the state department, that is what is being questioned by the BRO. The BRO is not questioning that why should we give you a pay protection. I worked in a PSU. I came to state government protected my pay. I went to BRO. BRO is saying state government should not have protected your pay. Are they authorized to do that? Can they question the state government?
Because
what they
lordship,
did?
here he resigned from the service, then joined.
Technical resignation has
No
to come.
lordship. They resigned, not a technical,
No,
from the PSU lordship, in the earlier year concept lordship, as per my instruction lordship.
PSU's pay, we are not too much bothered. We are bothered with the pay which was receiving in the state government
Lordship.
before we had come to BRO.
Lordship. We have asked some clarification from the Uttarakhand government, but lordship, till today we have not received. That's why we have stated in our affidavit, lordship, on what basis you have protected that.
No, is that even an MB within the ambit of your calculation that what pay protection? What was the last pay which was receiving from in the organization from where he has come? Prior to that, where was he working? It was not within your. Why are you so?
In fact, initially from the lower level, my pay was required to be protected. When it went up to the
But
highest
we may not
authority,
have time for a judgment.
any other thing, any other thing.
কি করে no? Huh?
नहीं, आपने अपना तो ठीक है।
খালি পারা যাবে না, খালি 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 করে দিন। Huh? Oh. We'll have this tomorrow. We'll continue. Okay. As the first item.
Okay.
We'll complete this.
I have some other fixed matter, item number 1 of number 20.
We'll accommodate you.
One
We,
item I have.
no, we just want to recapitulate that we have not made any notes. We are not under the impression that it can be disposed of. We'll dispose this.
At 2, then
2 o'clock.
Item number 1 at court number.
I am a
Tomorrow there is a larger bench.
Full bench.
Oh, yes.
Full bench.
That's a full bench. Okay. But we'll try tomorrow. We'll try tomorrow. We'll make some notes on the facts. But that notes is difficult to list again tomorrow.
All.
What is it?
First week of June.
June will be too. This is a matter of which year?
18.
No. Not at all. Tomorrow. Yes.
49, my lord, is one of those matters where we have filed a review where the persons were not qualified on the date of the advertisement, but that is one of the judgments.
Now, where is the paragraph?
My lord, same paragraph 2 of the writ petition, lordship will find that they were, the order reflects that they were qualified. And paragraph 2 of the writ petition, my lord, would show that they were not qualified on that day, they qualified in 2019.
Paragraph 2 at
My lord,
page
page 71, if lordship has,
7-1.
7-1, yes. Page 71, paragraph number 2, sub-para, my lord, that the petitioner further respectfully submits that the petitioner successfully passed DLED examination in 2019. Then the next paragraph, the petitioner more begs to state that the petitioner participated in the TET examination in 2019. There's one more aspect, my lord, which has recently come to light. Those persons with 18-month DLED, that the Honorable Supreme Court has held that they would not be entitled for fresh recruit. He is a 2019 18-month DLED.
We have not got to what has been stated?
He has completed, if lordship will find the sub-para.
DLED, yes.
The petitioner further respectfully submits that the petitioner successfully passed DLED examination in 19 from NIOS by enrollment number so and so. Honorable Supreme Court, my lord, in the month of December has held that 18 months DLED will not
18
be
months.
DLED will not be a qualification for fresh recruitment.
This is a 18-month.
18-month DLED. He is one 18-month.
You take steps.
That thing, my lord, I will.
We'll issue notice. No, that we'll have to file another additional affidavit. This is notice only the primary respondent. How many?
One.
Hmm?
One
respondent.
One respondent.
So it would not lage, huh? At this stage, notice is issued to primary respondent na lage. That notice for service or primary na lage na. So the to solve hobo to the respondent. It will not. Just the second last line would be not to be required on the at this stage. Notice is only issued to primary. One respondent prior to that also.
In that, the Union of India was a part. Okay.
You take steps.
I'll do that. Oblige me.
Item even inadvertently steps were not taken. I have taken it today, already taken.
Steps. Okay.
Otherwise, all the necessary parties 1 to 9 are represented on the first day, only the principals who are the proper parties.
Do office note dated 4/5/2024 reflects that no steps have been taken upon the private respondent. 10 and 11.
10 and 11 in the first.
Private respondents, comma. 3. BP Bora, the learned counsel for the petitioner, has submitted that such steps have been taken today. Full stop. Let office to verify and proceed. Full stop. List after 4 weeks along with service report.
Yes, plus an interim order.
Where interim order passed earlier to continue till the next date of listing. Private respondent will লিখবে এটা দুটো আছে এটা আছে প্রথমটা দুটো আছে respondents. In Ratul Das there are 2 private respondents.
2.
And the other one respondent.
2.
Both in 2.
Both.
2 respondents.
10 and 11 and 8 and 9.
Okay.